Item number 1.
Hello, in item 1, my senior Bijakam Parida is suffering from bronchial asthma. I
Sir,
pray for
I
2 weeks
requested
time.
on behalf of the petitioner on the ground of indisposition of London Senior Counsel, list this matter on 2 weeks.
Item number 2.
Okay.
I will please Lordship, I will in virtual mode, madam. This is a public interest litigation in relation to the Kotak Development Authorities area, where total population is around 5 lakhs and houses are more than 2,700. Let's see, can you look at page 13, my lord. There was a clear playground closed for the sports purposes.
You are inaudible. You are inaudible. Yes.
Now they are also trying to do other things other than the sports purposes. Minimum 52 players have been selected for cricket and other sports purposes from this area, which has been now government is giving to multiple for different purposes other than the sports.
No, how can we decide?
In an area where around 5 lakhs people are staying, there should be minimum sports area for cricket, for football, for outdoor sports for possible. Initially it was available in sector 7. Subsequently that is enclosed, maybe by the public purposes. Now it is only available at sector 11. I have given the copy, madam. This is my limited case before your lordship.
No, whether is it your case that there is no alternative
There is no yes, madam.
place for playing?
Pardon. Page 14 area, madam.
Have you filed your affidavit?
No, it's for the first time it is listed. Lordship say after 4 times it has been taken up today, but every time they took time. Lordship, question is that it was never meant for a playground. It was an open space. Now people used to play there, Lords. So it doesn't become a playground once people play there. Now the government has decided to have a indoor stadium and a multiplex. And now hockey stadium has already been constructed besides that. So what
Lordship, can it turn to page 14, madam? Lordship, can it turn to page 14? The map will categorically indicate there is a playground at sector 11, madam. Even, Lordship, can you see page 13? Playfield is also available by 11 by 1p in middle of the map, my lord.
Mr. Mishra, why are you creating a hurdle when your area stadium is coming up? A mini stadium is coming up and the state government, just you have heard the additional government.
Take me to that effect, my lord. Where from it is coming up?
Yes.
Let them file an affidavit, my lord. Minimum we can.
That is the instruction he has taken.
But
A copy and he has.
Because we have no other ground, other places than to play. My small kids are playing.
Please, do you have a copy? Do you have a copy?
Yeah, otherwise copy has been served upon me, Lords.
Please come to the statement in paragraph 4.1.
Lords. The land on the plot is lying behind the dispensary of sector 7. Is earmarked for playfield from very inception of creation of Kotak Development. The said land is being used by residents for all over CDF for playground. Except this land, there is no other land which can be used for playground. That instruction I can take notes whether there also stadium is coming up and also in multiple because there is no
Public interest litigation. Statement has been made in paragraph 4.1, which reads as under. Stop. Have you filed your affidavit? Have you supported your writ petition by proper affidavit?
but not in the new form.
Do it first. Do it first. Otherwise, this statement has no sanctity.
It was in 2022, my lord, application.
Mr. Counsel, what is the value of this statement? In 4.1, which is not supported by proper affidavit. 4 weeks' time is allowed for the petitioner to file additional affidavit to support the averments made in the writ petition in accordance with the requirement under so and so.
All right.
Item number 3.
May I please? This is a writ appeal against the order of the Honorable Single Judge. The brief fact is that the petitioner was allowed to appear the selection process for the post of CRCC, my lord. As per the selection guideline, he appeared written and viva, and for the Ganjam district, he was in 3rd position, my lord. A date was fixed for counseling. Due to mother illness, he came late, 10 minutes later, he appeared before the counseling, my lord.
Sir, counsel, every aspect has been taken into.
No, my lord, the court has insisted that due to non-attendance of counseling, my selection is bad, my lord.
Right.
But the collector himself, the committee himself stated in the order of the collector that is not a mandatory. He lets me come to page 42, my lord.
Now come to the order passed by.
My lord, that is the order. Order is that I have not participated in the counseling. That is admitted fact, my lord.
Yes.
I came 10 minutes later, but that is not the process of selection criteria.
Please come to paragraph 10.
My lord,
We don't think any grievance
Ma'am.
arise.
paragraph.
10 of the impugned order.
Well, that is they have rejected on that ground. That is the findings.
Yes.
Well, but the material is.
No, you approach the opposite.
10.1.
You approach come to paragraph number 8 of the impugned judgment. You approach
Wait a
the
minute.
opposite, come to paragraph 8.
Right.
You approach the opposite party
My
number
lord.
2 on the next day by taking a plea that you appeared counseling with 10 minutes delay.
Well,
So on that day,
My lord.
your case is that
My-
you approached 10 minutes after.
well,
You have not filed any petition.
well, that is a long distance. I have to go to the collector. My lord.
Not only that.
My lord, court directed
Not
the collector to
only-
consider.
Not only that. Now come to the last
My lord.
part of the order.
My lord,
While quashing the same, the court is of the view that since deployment as CRCC, what is
my lord, that is a diplomat.
and CRCC is not a vested right either of the petitioner or the opposite
My
party.
lord, that is correct, my lord.
Then
My lord,
this is correct, then where is it?
my lord, so come to page 42.
And then
my
further cluster once again and complete the selection process.
lord, 42 years also come to. I have no 42, page 42, my lord.
What?
Page 42 of the brief,
Yes.
whereas the collector has taken a decision, whereas the DO come DPC, essay submitted that counseling is being conducted for choice place of
We
posting.
shall not go into that in view of the observations made by the Honorable Single Judge.
Well,
That you don't,
well,
don't have,
my lord,
if you are saying that portion of the order is correct, then there is no vested
my lord,
right.
counseling is not
If
a
there is no vested
mandatory.
right.
My lord,
If there is no vested right,
counseling is not a mandatory for selection process. That is all my case. That is there. The government itself says, collector says, that is not mandatory. If it is not mandatory, my lord, I am meritorious candidate, my lord. I am simply thrown out of the selection only on that. No malafide, nothing.
they will make a fresh selection. This is what this.
But they have directed first selection means I have to.
They will do it. They'll do it.
My lord, I may be allowed to participate. They will also fix the time limit for the selection process. That will suffice.
Appellant in the present intra-court appeal has put to challenge an order dated 29/11/2023 passed by a learned single judge of this court in WPC number 33425 of 2023. The petitioner in the said case You were the opposite party.
I was the opposite party. Number five.
Was the opposite party number, was implemented as opposite party number 5. So stop. The dispute related to deployment as
CRCC, my
what
lord.
is this?
CRCC, Cluster Research Coordinator, that is a post.
Tell us what is CRCC?
But Cluster Research Center Coordinator.
Cluster Resource Center Coordinator.
Well,
That is not a substantive post.
Collector resource.
Center Coordinator, madam. Center Coordinator.
It is cluster.
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 what is
Center. Cluster Resource Center Coordinator, CRCC.
Cluster Research Center Coordinator bracketed CRCC.
Yes.
Comma, Huma.
Right.
So stop. The appellant's deployment was challenged in the said writ proceedings by opposite party number 5.
Well,
Full stop. After having entered into the controversy, the learned single judge allowed the writ petition with the following observation. Paragraph 10. 10.1.
point one.
10.1. Full stop. Next. Learned counsel appearing on behalf of the appellant while assailing the impugned order of the learned single judge has not disputed the legal position that deployment as CRCC is not a vested right either of this appellant or the opposite party number 5. So stop. Further, comma, the learned single judge, while disposing of the writ petition, has made a clear direction to opposite party number 2 to conduct a fresh selection process in respect of the said Huma collector and complete it in accordance with law. Full stop. Next. Such being the situation, comma, we are not inclined to interfere with the impugned order, which suffers from no legal infirmity. Stop. It goes without saying that learned counsel for the appellant has submitted that till date, no selection process has been initiated for the deployment. Stop. It is observed that if no selection process has been initiated, comma, despite the observation made by the learned single judge comma, the authority shall be under obligation to do it, to initiate it within a period of 2 months from today. Full stop. It goes without saying that the parties to the present proceeding, that is the appellant and respondent number 5, shall have liberty to participate in the set selection process.
Well, if not completed, well, if because the order is of if order of November completed. Well,
Item number 4.
If not initiated, completed.
My lord, in this case, the petitioner is the lessee and the opposite party number 4, the Tahsildar, he has issued notice after 36 years of the lease.
File your additional affidavit first. Have you filed?
My lord, I have filed it. In
You have
due-
filed.
My lord, I have filed it.
All right. Yes. Yes. What is your problem?
My lord, in the year 86, the disputed land has been leased out to by the opposite party number 4, Tahsildar Tangi Chaudhar, in favor of the petitioner. And after 33 years, the same lessee, Tahsildar, has filed an appeal before the sub-collector who has confirmed that order. And notice has been issued to me. And after obtaining the notice, I appeared and I came to know that after 33 years, this appeal has been filed. The Tahsildar has no locus standi to file appeal because he is the lessor. He has sanctioned the lease. And the appellate court has it is beyond his jurisdiction because on the basis of his confirmation letter, ROR Stitivan ROR has been issued to me. And after 33 years, this appeal has been taken.
Let us see.
My lord, section 7(1) of OGLS Act My lord, according to this section 7(1), the limitation period of appeal is 30 days. My lord, instead of 30 days, after 33 years, this appeal has been filed before the lessor who has
The
sanctioned.
appeal was filed under which provision?
My lord,
The land was settled in your favor.
my lord,
When?
in the year 86,
86.
my lord,
Under which provision of law?
lease, I am a landless. According to the government circular, it has been leased in my favor and I am in possession.
Where is that?
My lord, I have filed the ROR which has been issued.
Forget ROR. The land was settled in your favor. This is your case.
My lord,
The settlement must have been done under some provision of law.
my lord, there was a provision. There was a provision with landless. It will be issued to the landless. I am a
That is what we want to see. Because you must have a case that you fulfilled at least the basic criteria for settlement of the land.
My lord, in this case, my prayer is
Now, now we are giving you an extreme example. That suppose a person has 1,000 acres of land
my lord,
and some valuable piece of his favor on the ground that he was landless.
my lord,
All right.
my lord,
So there are, according to you, only landless people could be settled the land.
my lord,
All right.
my lord.
So where the test that is that scheme and where is the law? If you did not fulfill the fundamental criteria, then even if we find that there has been any procedural lapses, we may decline to interfere. So you will have to satisfy, we will not go into minor details, but we will have to satisfy that the land was duly settled.
My lord, in this case, my prayer is very specific. I have filed the impugned order.
Your prayer is specific, we understand that, but we are sitting in writ jurisdiction, Article 226.
My lord,
So even if we find that there is some illegality in the action, we shall interfere only if we find that that illegality is so gross
my lord, in his
that
order,
that requires interference.
my lord, in impugned order, clearly he has mentioned as per the instruction of the verbal instruction of the collector.
We will, Mr. Counsel, we will see every aspect. You just satisfy us the scheme, because according to you, the land was settled in your favor.
My lord,
This plea you are taking on the basis of ROR. So you must have been doing civil cases also.
my lord, after sanction of that lease order, then I have obtained the ROR. On the basis of that lease order,
We can understand that. We want to see the scheme or the law or anything which had the scheme of settlement of land in favor of the landless person. This is what we want to know. For the first time, you are addressing this court, of which I am the.
Is it under OGLS Act?
my lord,
Is it under OGLS Act?
my lord.
Please come to page number 12 of the writ petition and see the paragraph number 6.
My lord,
See paragraph number 6.
that the lessee is neither a landless person nor in possession of the land and utilized the land for the purpose of it has been leased out. Hence, the lessee managed to get a lease of the said. My lord,
What the authority mean to say that you have committed fraud?
my lord, my lord.
Yes.
This is the,
Then
my
how
lord,
can you
this is
get
the,
the relief?
this is the order of the sub-collector. This is not my, I have quoted the order of the
Appeal
sub-collector.
has been challenged on that particular ground that you are not a landless person. You posed yourself a landless person.
My lord,
Somehow or other got the land. Now it has
Whether
been.
you can satisfy us on that point or not.
my lord,
Whether you can show us this the provision or not.
my lord, I have come in this read on the ground that without limitation petition, the sub-collector has condoned the
We have understood your submissions. You please tell us. The land was settled in your favor on the ground that you are a landless person. Can you satisfy the court that when the land was settled, you were a landless person? It's a simple thing.
My lord, I am a landless. It has been reported by the RI and I have annexed that report. On the basis of-
You file an affidavit. Let your client file an affidavit that he was a landless person on the date when the land was settled. And we guarantee you that if that statement is found to be false, that a criminal prosecution shall be launched against him. You file an affidavit, we will see.
My lord, I will
You file an additional affidavit saying specifically that on the date of settlement, you were a landless person.
my lord, RI has reported it.
Forget RI. You please file. You must be knowing whether you had land or not. You are the best person to know.
My lord, I prefer 1 week time.
Yes. 1 week time is allowed for the
For clarification.
petitioner to file a
My lord, for clarification on which.
No. Just see, file an additional affidavit stating specifically as to whether the petitioner was a landless person as on the date when the land comma, which is subject matter of the present proceeding, was settled in his favor under this act, under the Odisha Government Land Settlement Manual, 1962. Act 1962.
My lord, I pray for 10 days. 1 week, 10 days.
2 weeks. This,
Okay.
this case on, so retaining its position. Mr. What we want to know, I'm sorry, I raised my voice. We want to know that the land was settled in your favor because you were landless. All right.
My lord.
So you are the best person to know whether you were landless or not. So you just tell the court, and you will have to tell the court on affidavit that you were landless.
My lord, the appeal is
Just a
pending.
minute, just a minute.
Why are you becoming
Just
impatient?
a
Please
minute.
listen.
Just a minute. So if you say that you were landless person on affidavit, we may entertain your writ petition. All right. But
My lord.
if we have, or a plea is taken that no, he was not a landless person, he had such and such land, then we may direct for your prosecution for making false statement before the court in writ proceeding. These are the aspects.
My
All right.
lord.
Are we clear now?
My lord, clear.
Or if we are satisfied that you were a landless person, then we will surely interfere with the illegal action of the opposite party, state government. All right.
My lord. My lord, due to the procedural error, I came in with.
Procedural error, despite having noticed the procedural error, we may decline to interfere. All right.
My lord.
Please keep in mind that Tahsildar has reported that you are not a landless person and has yet given that what land you have.
No, my lord, it has been done afterwards.
What?
That is
There in the appeal memo, please go through it.
my lord, in the appeal memo, he has
We will
filed. but-
consider. We will consider. Just come up with that.
Obliged.
Item number 5.
May I please, my lords. The petitioner for Lords is a registered person in respect of 3 business verticals having distinct GST numbers, my lords. Because for each concern, I have to have one different vertical. I have to one GST registration. I have 3 registration numbers. One is for my lords, Hotel Rasmi Plaza. Second, Rasmi Agencies, and third is Hardik and Co. 3 different registrations, my lords. My lords, under the GST law, my lords, in case investigation is warranted, then an authorization under section 67(2) is required from the competent authority. And here, competent authority has authorized the proper officer to conduct investigation in respect of Hotel Rasmi Plaza. Investigation was conducted on 10/8/2023. It continued from 5 p.m. to
Just a minute. Just
my lords.
67.
67 2. Yes. That only provides for authorization. I am not
Yes.
very much on that. Here there is authorization. And yes,
Just let us understand.
my lords.
Yes.
Authorized in writing, yes. This is available here. So, mirrors, there is authorization to conduct investigation in respect of mirrors, Hotel Rasmi Plaza mirrors. And based on that authorization, investigation took place to the place of business of the taxpayer on 10/8/2023, and it continued from 5 p.m. to next 1 midnight, 1:15 a.m. In fact, they mentioned 3 p.m. That should be a.m. Till that is 11th. Yes. Plus, what has happened in course of investigation, mirrors, this petition is called upon to make some deposits. Even if that can be done, but that can be done only by following due procedure of law, which is provided under Rule 142(1)(a), that is by intimation prescribed form. That has not been done orally. He said you deposit, and in the midnight at 11:45, the deposit was made, 33 lakhs. But while making payment, the amount was paid from Rospi agency's account. On the next day, again at 1 p.m., petitioner made payment from Hotel Rospi Plaza account of 17 lakhs. Now, so far as this payment of 33 lakhs is concerned, in respect of which that is neither in adjudication nor in investigation, nothing is there. It just paid from another account at the instance of theirs, So I applied for refund, under section 54 in RFD1, statutory online application was made. And now they rejected this on the ground that because for 2017-18, you have only one valid registration, that is of Rospi agencies. So therefore, your application for refund cannot be entered, rejected. Only particularly when, on the very next day, in Rospi Plaza's account, on the same situation, even if that is for 17-18, they have entertained and the money was deposited, allowed to deposit. It is deposited. Your Lordship, I am directly taking your Lordship's attention to the impute order. Your Lordship will kindly see page 56. The relevant portion, paragraph 2 and 3. Page 56 minutes. Before that, my Lordship will kindly see paragraph 1. After discussion on findings, after careful consideration of the submission made by
this order has been passed by whom?
This is passed by state tax officer.
Opposite party.
So
Opposite party number 1.
Is there any appeal lies?
Yeah, let's.
That's appeal lies. But here, as your Lordship have said, because the glaring error is surfaced with us, and as my Lords knows, there cannot be second refund application. Once it is rejected, there will be again fresh application, fresh proceeding. So therefore, it's an error apparent and glaringly clear, telltale. That is why I am under 226 for Lordship.
We will become appellate authority then.
No, not appellate authority. I cannot,
And you would
dare
not
say so.
like the High Court to be reduced to that position.
Because the only problem is, money, your Lordship, when I am aware of Article 265, as my Lords knows, without authority of law, no money can either realize nor retain. So here, there is no investigation, nothing in respect of Rospi agencies.
No, just tell us which jurisdiction they do not have, or what order they cannot pass, which the High Court can pass, exercising jurisdiction under Article 220. Everything can be done by the appellate authority. They are in a better position to determine your dispute.
This is a case petition for Rospi agencies, not Hotel Rospi Plaza, who was subject to investigation.
Approach. The petitioner has put to challenge in the present writ application and order dated 9/10/2023 passed by the opposite party number
1.
19/10/2023.
1910.
19/10/2023 passed by opposite party number 1. This right. After some argument, and senior counsel appearing on behalf of the petitioner accepts the legal position that the petitioner has alternative remedy of appeal under section
107
107 of
OGST Act.
Odisha GST.
OGST Act 2017. So stop. Next, as the petitioner has alternative statutory remedy of appeal, we are not inclined to entertain this writ. As an effective statutory remedy of appeal against the impugned order, we are not inclined to entertain this writ application under Article 226. Writ application filed under Article 226 of the Constitution of India. This application is accordingly disposed of with a liberty to the petitioner to prefer an appeal against the impugned order.
Period is still there for appeal period?
Appeal period is there.
Your Lordship, I am appealing for opposite party number 2 and 3.
I am for 1.
Give us.
Good.
Item number 6.
My lord, I am submitting one brief note of submission in this matter.
Please come this side.
Right, at the first instance, the assessee was before the assessing officer. Before when the disputed expenses, my lord, the performance incentive was treated.
Just a minute. For the first time, speaking for myself, I am taking up an ITA. Therefore, I wanted to know what is ITA.
My lord, under Income Tax Appellate Tribunal, my lord.
Under which provision?
Income tax.
Which provision?
Yes, my lord, 260A. 260A, my lord.
260A. Just a What is 260A? Please read it. I have.
My lord, appeal to High Court, my lord. An appeal shall lie to the High Court from every error passed in appeal by the Appellate Tribunal before the date of establishment of National Tax Tribunal if the High Court is satisfied that the case involves a substantial question of law, my lord. And the Principal Chief Commissioner or the Chief Commissioner or the Principal Commissioner or an assessee aggrieved by any order passed by the Appellate Tribunal may file an appeal to the High Court, and such appeal under the subsection shall be.
So what
Well,
is the substantial question of law?
My lord, here is a substantial question of law, my lord, the expenses. My lord, the opposite party has taken some expenses that has been, disallowed by the assessing officer. Again,
So what is the substantial question of law?
my lord,
You must have formulated. And if you have not formulated, you please formulate that.
my lord,
Because while hearing an appeal of this nature, we are required to know what substantial question of law is involved, which is to be determined by the High Court.
yes, my lord. My lord,
Which is
Section
that?
37 of Income Tax Act contains certain criteria, which expenses are to be allowed, which expenses are not allowed, my lord. So here, that expenses which have been taken by the assessee, the assessing.
No, please forget the facts. Just tell us in 2 sentences or 5 sentences or 10 sentences that this is the substantial question of law, which this like you do in second appeals.
My lord.
Otherwise, even the order may be incorrect, we shall not interfere.
My lord, page number 8, my lord.
Page number
Page number 8, my lord. In the
8 of your brief.
Yeah, bit.
Yes.
My lord. Whether on the facts and circumstances of the case, the learned ITAT was justified in allowing the claim of the assessee of performance incentive.
Mr. Your appeal can be dismissed on just by quoting what a point you have taken. That is that substantial question of law? Just see, read it again. Please read it again. Whether on facts and circumstances of the case, the learned ITAT was justified in allowing the claims of the assessee of performance, incentive being uncertain, liability made on estimate basis. This cannot be substantial question of law. Please formulate it. We are ready. Of course, in the background of the facts which are involved, you can make out a case. We don't know. Come out with your specific case that this is a substantial question of law which has wrongly been dealt with by the appellate authority. Otherwise, the decisions of the appellate authority are final. Whenever you want, if you can do it.
My lord.
Come to subsection 4. Come to what the appellate court is required to decide
My lord.
the question of law and refer the matter back. If the court is of the view that the question has not been rightly decided.
Right.
Otherwise, please see subsection 4.
Section 260A, subsection 4.
Well, the appeal shall be heard only on the question so formulated, and the respondent shall, at the hearing of the appeal, be allowed to argue that the case does not involve such question.
Yes. So if you want, we can
Right.
decide right now. Or if you can improve, we would like to learn from it.
To say, my lord. Right.
As requested on behalf of the appellate, list this matter on. Or you have filed this appeal casually, like under the instructions of the government of India that some appeal has to be filed, therefore file it.
No,
As requested on behalf of the appellate, list this case on 1B, Tuesday. For him to satisfy this court that this appeal involves a substantial question of law for it to be maintained in view of the specific provision under section 260, page number 260, 260.
What is that provision?
260.
260A, na?
Under section 260A of the Income Tax Act.
Item number 7.
2 weeks to file additional affidavit. Supplementary affidavit.
2 weeks.
Item number 8.
May it please your lordships. My lords, Annexure 5 is the impugned order of the Honorable Single Judge, my lords. My lords, the question that arises in this petition is, my lords, whether the finding that condonation of delay was justified is correct in view of the facts of the case, my lords. My lords, the elections result was declared on 2/3/2022. He was elected as a Sarpanch under the Orissa Gram Panchayat Act. So within 15 days, he has to file an election petition before the competent tribunal. That is under section 31 of the Orissa Gram Panchayat Act, my lords.
Yes.
So that works out to 17,322.
17,3.
322. Results were declared on 2/3/22.
Yes,
And within 15 days, he has to
17/3/2020.
22.
Right.
Now, my lords, he files this election petition on 4/4/22. There is a provision for condonation of delay upon sufficient cause being shown, my lords. Now, his explanation is that from 10 to 17, I was being treated by a doctor. The doctor denies it. I will take your lordships to that portion of the
You are challenging the condonation of delay order.
my lords. Because it's an election, it's up to your lordships, my lords.
Only 17 days. And that's the finding, 18 days, only that's the finding of the learned single judge, honorable single
Or
judge.
there is some very
On the first
no,
instance,
serious issue that
Not serious.
London senior counsel of the court is standing.
at an interim
My lords,
stage,
it's a political thing, so
third attempt at an interim stage.
The appellant, the present appeal has put to challenge an order passed by a learned single judge of this court dated 8/1/2024, passed in WPC number 31472 of 2023. The short facts of the case are that the appellant had contested election for the post of Sarpanch
Sarpanch
of which panchayat?
of
Sarpanch of a panchayat. So stop.
Pollipada, 135 PALLIPADA.
He being unsuccessful in the said election. He, so stop. The appellant was the returned, you
Yes,
were returned candidate.
Returned.
So stop. One Balram Swayam filed an election petition. Was returned. Returned candidate. The result of election was the election result was declared on 2/3/2022. So stop. Which act is that?
Orissa Gram Panchayat Act,
Odisha Gram Panchayat Act
1964.
1964 provides for an election petition against elections under the said act.
Yes.
With the stipulation that such petition could be filed within 15 days from the date of election. It also provides the provision also. There is a provision for condonation of delay also under the
Second proviso.
act.
Second proviso to section 31.
Second proviso to second proviso to section 31 of the act states that if an election petitioner satisfies the concerned civil judge bracketed junior division that sufficient cause existed for the failure to present the petition within the period aforesaid, comma, such court, the civil judge senior division, it's not a court. The civil judge bracketed junior division may in his discretion condone such failure. So stop. The unsuccessful candidate, that is Balram Swain, filed an election petition on
4/4/22.
22. And thus his election 22 with an application for condonation of delay, comma, there being delay of election petition. Election petition and election petition number 4 of comma, there being delay of 17 days in filing the election petition. So top, the said delay has been controlled. The said delay came to be condoned by the learned civil judge by an order dated 14/9/2023. So stop. Such order condoning delay became subject matter of challenge in WPC number T1472 of 2023. So stop. This said at the instance of the petitioner, appellant. So stop. The writ petition has been dismissed by the impugned order dated 8/1/2020. 8/1/2024. So stop. Learned counsel appearing on, learned senior counsel appearing on behalf of the appellant has argued that the plea which was taken by opposite party number 1 for condonation or delay was factually incorrect, and thus the delay has been wrongly condoned by the trial court, by the learned civil judge,
By the tribunal.
which
By the
Election tribunal.
Yes.
Election tribunal.
election tribunal by the learned civil judge, which ought to have been interfered with in the writ proceeding by learned civil judge. Full stop. We have carefully perused the.
Well, my further submission is that every single day's delay should be considered, which has not been
He
done.
has argued that the trial court ought to have considered every single day delay while considering the application for condonation of it. So, next. We have carefully perused the impugned order passed by the learned single judge, as well as the other materials available on the court. We have given our thoughtful consideration to the submissions advanced on behalf of the parties. We are of the considered view that, keeping in mind the period of delay, exercising writ jurisdiction under Article 226 of the Constitution of India, learned single judge has rightly declined to interfere. So we do not find any merit in this appeal, which is accordingly dismissed.
Obliged.
Item number 9.
This is an appeal, my lords. Intercourt appeal against the order passed in a contempt petition by the Honorable Single Judge of this court dated 7/2/2024. The lordship finds that order at page 85.
Page?
Page 85. It's a short order. I'll may be permitted to take your lordships through the order.
Just a minute, just. Yes, please.
Matters.
Hmm.
Matters taken up through hybrid arrangement on perusal of the affidavit by the opposite parties number 2 and 3. This court does not find any satisfactory reply. This court is of the view.
Sorry, somehow or the other I missed. This is the next third.
I'm sorry, Madam.
You are at page 85.
Page 85.
85.
85.
85. Oh, yes.
Madam.
It is there.
This court is of the view that regularization of the services of the petitioner should have been done from the date of his joining the post, as he was appointed against a sanctioned post by way of a valid selection process. Hence, this court, as well as the apex court, have held in a catenary of decisions that regularization of the services should be done from the date of joining, not from the date of the judgment. Now, my lord, the opposite parties' contemners are directed to file an affidavit in the light of the above observations on or before 20th of February, my lords, which is tomorrow. Now,
you are challenging this order.
My lords, I'm challenging this order, my lords. I knew that question was coming from your lords. You know, there's a direct Supreme Court decision. There's a direct Supreme Court decision under section 19 of the Contempt of Court Act. The Honorable my lord, single judge could not have passed an order commenting on the merits.
Contempt proceedings.
Yes, it's a contempt proceeding order. And this is, my lords, I am on an intercourt appeal, not on an appeal under section 9, arising out of section 19. I'm on an intercourt appeal. There's a my lord. In light of the direct...
Just. What was the order in the original?
My lords, order. I'm grateful, my lords. Lordship may kindly come to page 32, the operative portion of the order of the Honorable Single Judge, which was, my lords, eventually confirmed. The division bench confirmed it. Even the apex court confirmed this order.
Oh, what is that?
Page 32, the original order, paragraph 22. I'm sorry, my lord, I'll take your lordships of para 21 first. No doubt, after establishment of the BPUT, the institutions under the control of BPUT, Biju Patnaik University of Technology, that's a Government of Orissa University, State University, which controls all the technical institutions in the state, have to fill up the vacancies in accordance with the provisions of BPUT Act and rules framed thereunder. If the institution had been taken over, along with its staff, in case the BPUT has to take necessary steps for regulation of the services, instead of terminating them, even though the employees have not been appointed under the provisions of the BPUT Act and the rules. 22. In view of the matter, this court is of the considered view that the opposite party should observe the petitioner on regular basis against sanctioned vacant post, taking into account the length of services rendered by him as a lecturer in mathematics, in which he is continuing, without insisting upon him to undergo the rigors of the selection procedure laid down under the BPUT Act and rules framed thereunder. Reasons being, in the meantime, the petitioner has become overaged and he has also been exploited for 20 years for no reasons, though he has qualified in all the interviews conducted by the authorities for his engagement on contractual basis. This petitioner being not a backdoor entrant to the service, the opposite party university should extend all consequential benefits as due and admissible in accordance with law as expeditiously as possible, preferably within a period of 4 months.
Yes.
Now, this is order was passed on.
The only thing is,
I have not been served with a copy of the
please, sir.
appeal.
In course of the day,
meanwhile, you please don't press the contempt.
Contempt is tomorrow, my lords.
You don't press.
No, I am not pressing tomorrow. If you also will hear this matter anytime.
We will hear.
The only question, sir, because my lord is referring to the judgment.
No judgment.
The judgment which has been upheld by the division bench as well as upheld by the Supreme Court. So I'll take your lordship to paragraph 6 and 7 of that paragraph of the judgment, where it has been dealt with. If your lordship will look to that paragraph 6. Then I'll take your lordship to a judgment of this division bench of this honorable court, where the same thing has been dealt with. You'll also kindly come to paragraph 5. Of course, I don't have the page marker because brief has not been handed over.
Page 24.
Kindly come to paragraph 5.
Page
24. I'm obliged.
Senior friend is referring
Yes,
to page
thank you.
24.
On the basis of, you'll also straightway come to paragraph 5 towards bottom, third line. The petitioner has filed an additional affidavit on 14/10/2015. I think you'll also get it.
On the basis of paragraph 5.
Yes. The petitioner has filed an additional affidavit on 14/10/2015.
No, paragraph 5 is something else.
No,
Yes.
paragraph 5
Has filed an additional affidavit, yes.
Yes, the petitioner, yes, I'm obliged. Yes, already get it. The petitioner has filed an additional affidavit on 14/10/2015, annexing the information received under RTIR in Annexure 49, wherein question number 7 and answer to the said question is stated as follows.
No, we are putting just one question.
Sir,
Was there any direction issued by the writ court that the regularization shall be from the date of initial engagement? Is there any direction?
so though there is a specific direction, if you also look to paragraph 6, because why I'm saying so, because that I'm backed by the judgment of this court in a contempt matters. In Annexure E to the additional, just I was reading that what is the information, right to information, question number 7. I'm reading at page 5 of the judgment. Question number 7, the above department, the contractual appointment against the clear vacant post, sanction post, or not at the time August 2002. Answer. As there was restriction for filling of the vacancy in the regular manner by finance department, as indicated in paragraph 5, contractual appointment was made against the sanctioned vacant post. Then para 6. In Annexure E to the said additional affidavit, it is stated that as against 2 sanctioned posts of lecturer in mathematics, 1 post is vacant. Therefore, the petitioner is continuing in other sanctioned posts. Since the petitioner is continuing a lecturer against the sanctioned post on contractual basis by following due procedure of selection, he could not have been denied regularization by the authority in as much as the reason for allowing the petitioner to continue as contractual engagement is well founded from the answer given in question number 7 pursuant to Annexure 49, wherein it has been stated that due to restriction of filling up the vacancy in regular manner by the finance department, contractual appointment was made by the OUAT against the sanctioned vacant post. This clearly indicates that at no point of time the fault is with the petitioner for such contractual engagement made by the authority. If the reason given by such employment is financial crunch, in that case, the petitioner could not have been denied the regularization of service. Admittedly, the petitioner is continuing in the second post as lecturer in mathematics on contractual basis for a quite long time. This clearly indicates that there is need of his continuance of service against the vacancy as available. And after exploiting for so many years and after the petitioner became age-barred, he cannot be said that should come through the process of selection by following recruitment rules governing the field. After creation of the BPUT's College of Engineering and Technology has been placed under the control of the said university, and as such the service of the petitioner was also placed under BPUT. Now also look at the judgment of this court in a contempt matter, a division bench judgment of a coordinate bench, of course, the reliance of certain judgment of the Supreme Court. No, don't give it. So here also case of regularization. Also kindly just back the admitted facts in the first paragraph and the above said group of contempt. I think you also get it. The beginning of the order. The above said group of contempt petition are filed by complainant petitioner requesting this court to initiate the contempt proceeding against the respondent for their alleged disobedience in not complying with the direction issued by this court in the judgment dated 23/4/2014. Passed in Civil Appeal number 4809 of 2014, along with other batch of appeals. The operative portion of the order passed in the above appeals reads as follows. We accordingly direct the appellants to implement the order of the division bench of the High Court, thereby continuing the respondent in their service and extend all benefit as have been granted by it in the interim judgment. contempt petition number so and so was first taken up on such and such. When this court ordered the issuance of notice, subsequent the other conducted contempt application, also skip over. Para 3. By later number so and so, the government Jharkhand Road Construction Department issued a notification dated 15/9/2014. But this judgment of the Honorable Appellate Court, of course, to one of the complainants, the relevant portion of which reads thus. This is a quotation. In compliance with the order dated so and so, the Honorable Supreme Court in civil appeal number so and so, the cabinet sanction has been obtained in the meeting dated 2011/9/2014 and by department resolution dated so and so. We dated so and so. Services of C. Paras Kumar as assistant engineer on ad hoc basis are hereby regularized from his date of joining, that is on 27/6/87. Instead of 81, that was the directive.
No, but why are you, what is the proposition laid down?
Proposition laid down, even if they have been regularized from 87, but in the contempt court, it was said it should be from the date of joining. So in the contempt also, the court have a grand direct that from the date of joining by reading the entire pleadings of the parties and the judgment, the very purport of the judgments. That is what I'm trying to temporalize.
Maybe difficult. See, in contempt jurisdiction, the court is required to see that the court's order is implemented.
Yes.
2. The court can punish only when the violation appears to be willful.
Yes, willful, deliberate, that's right.
Violation can be willful only if, based on the direction issued by the court, the contemptor was required to do a particular thing. So if the contemptor was required to do a particular thing in the light of the direction, of course, taking into account also other observations made in the order.
That's right. That is what.
So he cannot breach any part of the order.
Right, sir.
He is not to comply the only that part of the order. If that is there, yes.
But that is what exactly I'm trying to bring.
No, what we could gather from your submissions is that you don't want them to be punished, but you want us to extend further or to pass further orders over and above what was the direction issued in the report.
No, not exactly that. With all respect, my entire submission for RCP is whatever the judgment has been rendered in a case which was filed in 2005 and where this observation has been made, and this is the finding on the basis of which the conclusion has been arrived at, and matter has been appealed in the higher forum by the apex court. Now the question is, in the guise of implementation of the order, they will say that we are regularizing from the date when the judgment was passed.
When did you file your contempt application?
Sir, I filed the contempt application. Contempt application was filed in 2017. And the writ application was filed in 2005.
Therefore, you could have questioned their action by filing a separate writ petition.
Sir, that's the point. So by that time, the matter was carried to this division bench and to the Honorable Supreme Court. So now the question is that, sir, now they implemented the order in 2020, saying that whenever the judgment was passed from that date, this is exactly the case. Just have a glance. If I maybe
it was later modified.
Just one.
This is quite technical thing, Mr.
Sir.
Later modified to the date.
I do follow what your lordship said, that in a contempt application, the court has limited jurisdiction, only question where there is a deliberate or intentional.
And the Supreme Court has deprecated the practice of issuing further orders in contempt jurisdiction.
Sir, I've also brought that judgment.
2006, volume 5.
Can you also look to paragraph 10? I have also my own limitation. I just bring to your lordship's notice. Paragraph 10 of that judgment. This judgment. Here is because I'm showing it is a case of regularization. Yes. But the court, in the content matter, to what extent the court can say, sir, paragraph 10. Therefore, the learned senior counsel for the complainant, Mr. Pipira was appearing for the complainant. Therefore, the learned senior counsel for the complainant has submitted that the purport of the judgment and order of the High Court and this court are that the complainant and are entitled for regularization in their post from 1981. That is from the date they have been appointed as a junior engineer in the department of the state government of Jharkhand And the said post of the complainant have been upgraded to assistant engineer by giving them promotion pursuant to the cabinet decision, para 11. Therefore, he has prayed that they are entitled for regularization in their post from 1981. That is from the year they were initially appointed to the said post and not from 87, as has been notified to them by the respondent in the above mentioned notification. As the same does not amount to full compliance of the court direction issued in the judgment and order, as has been submitted by the Learned Senior Counsel for the complainants. Therefore, he has urged that there has not been full compliance of the operative portion of the judgment. Operative portion of the judgment, as I read before, Lordship, that is, we accordingly direct the appellant to implement the order of the division bench of the High Court, thereby continuing the respondent in their service and extend all benefit as has been granted by it impugned judgment. Impugned judgment, to nowhere it has been said from which date it has to be regularized. Then, sir, paragraph 12.
Then we straightway come to paragraph 18.
Yes, sir. Paragraph 13 and
18,
8, yes, 17. 17 and 8, yes.
Yes.
However, in our considered view, the reliance placed upon the judgment and orders of the High Court as well as the court to support the contention of the complainant for the reason that there is a willful disobedience on the part of the respondent as they have partially fulfilled the direction given by the court as well as the High Court with regard to the regularization of service of the complainant from the year 87. However, further direction issued to the respondent to regularize the service of the complainant from the date of their initial appointment of junior engineer, that is from the year 1981, not complying with the direction issued by this court from the above mentioned here, would amount to deprivation of the legitimate rights of the complainant as determined by the High Court and this court in the judgment and orders. After taking the entire litigation, pleading documents on record and the rival legal contention also on behalf of the parties in consideration, we direct the respondent to comply with the above direction after properly understanding the purport of the judgment and order of the High Court as well as this court. So
despite the fact that specific argument was made that regularization should be from that date.
That's it. That is exactly my sir.
We will see what can be done.
Sir.
So don't press your
tomorrow I'm not pressing. I'll
press your contempt application.
Keep it, yes.
And
Minutes.
we are adjourning to
Whenever,
Sir,
whichever date you
comes to my mind, Miller. I was just opening the brief. Sir, a person, if will pursue the remedy available to him right from 1993 and matter was concluded in 2020. And this is the observation of this honorable court which has been upheld. Can it be totally bypass all the finding and it said because it is a contempt, therefore you have to again pursue the matter from beginning?
the whole difficulty is that when I'm again speaking for myself,
sir,
I create a kind of room and
sir,
I confine myself,
sir,
within the four corners of
the contempt of court, sir.
Jurisdiction.
Sir, your lordship also consider at the same time whether such an action is a deliberate action or not.
If that is there,
that's it.
See, if the court finds that it was deliberate to disobey willfully, then the question would be different.
Sir,
I'll be a different person altogether.
Sir.
But
yes, sir.
But see, this is a quasi-criminal proceeding.
Sir. Sir, here is a case in the first instance when the contempt was, they appeared and filed a contempt. They said that you have to be appointed as on probation basis. The court asked that where to get the jurisdiction to appoint him on probation basis. Then they took time and they said that from the date of his joining, that another affidavit. In this context, date of judgment. Like this. I'll bring to your lordship's note. Is that your lordship's whatever?
As for what we are dealing with? For what are we attending?
I'm filing the
Leave this matter on 2 weeks. So, senior counsel representing the opposite party number
1
undertakes that in the meanwhile, the opposite party number 1 shall not press
pursue the contempt
application. Pursue the contempt application, not pursue the contempt application pending before the learned single judge.
For the time.
Application, give the number.
Well, it's contempt application number 1383 by 2017. 1383, page 85. 1383 of 2017.
All right.
Item number 10.
Grateful. Urgent copy of your lordship.
Listed again after 2 weeks. It should be
2 weeks. You will have the date also.
Yes.
Can we be favored with an urgent copy of your lordship's order?
You will get.
Grateful, my lords, grateful. Obliged.
Item number 10.
May I please, your lordships, the present application is filed against the order passed by the opposite party number
Is
2,
it
my lord.
properly supported by an affidavit?
My lord.
Your affidavit is in order.
No, that is, my lord, under GST law. The order is passed digitally, my lord. No, my lord, I have not.
What is this about?
Your lordship, it is about day before yesterday, your lordship has passed due to non-constitutional GST
Tribunal. So
tribunal.
it is covered.
Exactly.
So bank account, my lord, has been freezed and
On payment of
Pay 20%.
obliged, my lord.
Oh, what is that?
42015.
that order has not been
Tribunal
uploaded.
has not been passed.
Uploaded for that reason I could not.
Order has not been uploaded.
Your lordship, I'm sorry, your lordship.
Just a minute.
42015, the lead matter was that.
It will be uploaded.
Your lordship, your lordship.
Huh? Why? All right.
Your lordship, grateful.
Item 11.
May I please, my lords? My lords, kindly turn to page 92, my lords.
Yes.
My lords, page 92 is a summon dated 24/7/2019 issued by the state GST authorities for investigation for the period, my lords, July 2017 to July 2019, my lords.
So, but why have you come against notice?
My lords, I am, because my lords, the person who has issued notice is not competent to, by operation of law, he is not competent to issue notice. That is my case, my lords. My lords, this is the summon issued by the state GST authorities for period July 2017 to July 2019, my lords. Again, my lords, kindly turn to page 105, my lords. First.
Is he correct in his submission?
Your lordship, there are two proceedings, your lordship. First, the
No,
state.
is he correct in his submission that the authority which has issued the notice did not have the jurisdiction?
No. Your lordship, he has jurisdiction. He has jurisdiction.
My lords, kindly turn to 105, my lords. Page 105, my lords. This is a summon issued by the state GST authorities for the period, my lords, 1/7/2017.
Yeah.
My lords, the period is important, my lords. 1/7/2017 to 18/4/2022.
Yeah.
For alleged evasion and other things, my lords, investigation is pending before the state GST authorities, my lords. In the meantime, what happened, my lords, the central GST authorities, my lords, page 91, my lords.
So from page 96, you took us to page 107.
105,
and then to again to 91.
91, my lords. 91, my lords. This is the summon issued by the central GST authorities, my lords.
91. Yes.
For this very same period, which is under investigation by the state authorities, the central authority issued summons for production and documents and other things. Again, my lords,
No, then why are you not responding to the notice?
my lords, I responded, I filed an application, I have annexed that, my lords, on the circular, my lords, the circular says, my lords, when one authority initiates the proceedings, either state or central GST, he has to conclude it and take it to the logical end, my lords. Here, my lords, the state authorities in session of the matter and have issued summons for production of documents and other things. For the period 1/7/2017 to 4 April 2022, my lords. Now, my lords, the central GST authorities, for the very same period, they are not competent to issue notice. This is the circulars. Is specifically states that.
So you are challenging which notice?
My lords, notice under Annexure 1 by the central GST, because, my lords, by the time central GST authorities issued summons, the state GST authorities have already issued summons, and that is under investigation by the state GST authorities.
How can that be done?
There cannot be two parallel.
Absolutely. Your lordships going to the 2530, your lordship kindly have a glance to the earlier writ application is attached to 24358/2022. And there your lordship see the order dated 5/3/23. Your lordship clarify everything, Lord. Kindly see the order dated 15/3/23.
In the present proceeding?
In WPC number 24358 of 2020.
In
24358 of
the connected writ.
Connected writ, your lordship. Kindly have a glance that order.
Connected writ?
Yes, your lordship. There I have also filed the counter affidavit.
We will come within 5 minutes.
Your lordship. By the central GST authority on the ground that 6(2) of the Act has been violated. Because the contention is that the issue which has been, someone has been issued, that both the authorities are issued same.
Have you filed your affidavit?
I have already filed, your lordship, see. And that proceeding, my lord, he didn't appear. He didn't appear and respond to the summon. Thereafter, my lord, 24, which has challenged this order, if demand comes so cause notice, he has challenged it secondary. And that so cause notice, it has been stated that within 30 days you appear with your adjudicating authority and explain the facts. Now you will also see section 6(2) for a moment before I go into the detail of the counter affidavit of the central GST.
Yes.
The heading is authorization of officer of central tax as proper option in certain circumstances.
You are placing which provision?
Provision section 6 subclause B, which has been relied by my petition counsel.
2B.
2B, subsection 2B.
Yeah.
Where a proper officer under the Central Goods and Services Act has initiated any proceed on this subject matter, that is important. On this subject matter, no proceedings shall be initiated by the proper officer under this act on the same subject matter. That means, Lord, if the same subject matter, both the authority cannot initiate proceeding. Now, lordship, see the order dated 15/3/2023 passed in WPC number 24358 of 2022. Kindly have a glance. That will lordship see.
WPC number
24358 of 2022 is a Mallard's tag of matter, Lord.
Which page?
Order dated 15/3/2023, your lordship.
15/3.
Yes, last paragraph, lordship. See
which order? Which number? Order number?
Order number, Lord. First order, lordship. First order.
First order.
Yes. There, Lord, the State Council stated.
Second order.
Yes, sorry, my lord, sorry, second order. Yes. There the state council stated, my lord, that has been, state council stated that the proceeding which are initiated by the central GSTs is not the exact issues. The central GST issued the, my lord, the summons.
You are reading what?
Let the order, your lordship, see 15/3/2023 order.
Which paragraph?
Para, my lord, third, I think third paragraph, your lordship. I missed that third paragraph. Their lordship, see the
Submission of the London Council for the petitioner has been mentioned.
next part, state council.
State Council, additional standing council
Yes.
contended that if the period is different, then the question of transferring the matter to so and so doesn't
Yes.
arise.
That is like 2 years. One is 17/18, another is
Order number?
This 15, that is the period. He's putting reliance on this submission.
Yes.
yes.
Yeah.
Then my lord,
Four we are seeing.
then my lord, that is different matter as contained in the state and the both the center. Now your lordship, see, he didn't appear, my lord. He didn't raise any objection on the response to the summon, my lord. In response to summon, my lord, he didn't appear, my lord. Thereafter, my lord, the authority has passed the show cause demand come show cause notice which is annexed in second writ application. Now his contention is that it is a same subject matter. Your lordship, see page 15 of the order, page 24, my lord.
No, in that order,
Yes,
paragraph number 5, your contention has been recorded.
yes.
So that contention reads that that is the particular period, and that is included within that period. That period, the summon period,
Yes.
that is July 2017 to July 2019.
19.
That is included in that period.
Now your lordship, see the second, that is what I'm pointing out. Your lordship, see the second writ, page 27 for a moment. Second writ.
Second writ.
Second writ. What is the before you go,
Second writ means what? 24358.
no, Millard 2 writ. One is Millard, just I'm placing Millard 24358, where Millard the petitioner challenges summon. That basing on that summon, Millard, the second writ Millard filed challenging this demand come show cause notice in 2530 of 24. That 2 writ, Millard, same petitioner tag off with
Yes.
in this writ, lordship, kindly straight away, lordship, go to page 27, running page 27 of the brief.
Yes.
And you will also see the details which are mentioned 10/3/22 to 28/3/22. Here is a case,
Page
Lord,
27.
running page 27 of the brief.
Quantification,
Quantification has been made.
26 start from 26.
Yes.
Dear Lordship, find quantity value, Parameshwar strip, so and so, so and so. Here, Millard, that is a non-payment of GST. Non-payment of GST. And if your Lordship see the subsequent page, he has been directed to appear before the adjudicator within 30 days and file a response. If Millard he is paid that amount, he has to be free from his liability. Because Millard, the adjudicator is adjudicated basing upon the evidence produced by the petitioner, Millard. He has not appeared before the assessing, the proper officer in response summon.
Mister, he is raising a very fundamental question.
Yes.
That in respect of the same transaction.
Yes.
Same
Period. Period, my friends.
It is
same period.
Yes.
Same period. Two authorities could not have issued.
absolutely correct, Millard.
That is the question.
There is no same proceeding. The word is matter, similar matter. The why I'm placing that section subclass P, same matter, not the same produce, same matter. Here, Millard, non-payment and the state GST has been wrong abandonment of the ITC. The two issues, Millard.
Wrong?
Wrong abandonment of the ITC. The fake dealer, all these things, he has been taken some ITC that has been disallowed and take cognition of the issue by the state authority. We are trying to establish a case where he has not paid the tax. There is two issues, So it is not the same matter as clause B of section 6, subsection 6 to B. And read petition is now influxuous because it has already been concluded with a so-called demand cum so-called notice. If he could have a case, he could appear before the authority explain. You see, this is the issue which has already been explained before the state authority. Now you have no jurisdiction to issue further order. He didn't do so, Miller.
So according to you, the subject matter is referred.
Yes, Your Lordship.
Your Lordship, in addition to my learning senior CGST council, Your Lordship, there are two cause of action. Your Lordship, different cause of action, Your Lordship. There are two sorts was conducted. On 24 July 2019, the state authority has conducted a search on the allegation is that wrong availment of input tax credit by the petitioner, Your Lordship. So against that, so-called notice summon have been issued under section 70 to the dealer, to the petitioner, from 1/7/2017 to 24/7/2019 till the date of search. So that is a proceeding, Your Lordship. That proceeding was going on. So central, this is the proceeding was there, state proceeding. So far as the central proceeding is concerned, Your Lordship, on 31st March 2022, there was a search conducted by the central authority. Pursuant to this search, they have issued the summons by clarifying that you have seized some material and they have clarified that you have sold the goods without issuing invoice and without paying the GST. For that, the central GST authority have issued the summons and this so-called notice for Your Lordship wrong not payment of GST. So both proceedings are different. So the state GST authorities are conducted a proceeding on different subject. Central authorities are conducted the different subject, Your Lordship. Just we have issued the latest summons for the overlapping period what the petitioner alleges. Your Lordship, only to look into, Your Lordship, because we cannot take any action because the central GST authority is in force for the subsequent period. So for the previous period, we have issued the notice. So that is the case, Your Lordship. So let him appear, it is a so-called notice challenge. So let him appear before the central authority so far as the so-called notice is concerned. And so far as the summon proceeding for the prior period, Your Lordship, let him appear before the... So there is no overlapping, Your Lordship.
That's all.
Your Lordship, see the page 28, paragraph 9. There, Your Lordship, the demand cum so-called notice has been directed to appear before the authority. And so far as summon issues, summon has been challenged, that is the order WPC number 24358. It has now influenced because it merged with the order of the order and the notice issued, demand cum so-called notice. Now this in demand cum so-called notice, even if assuming to the sake of argument his case is correct, then he can file before the authority that this is the issue which has already been considered by state authority. You have no jurisdiction to consider again. He has a case, he may discharge from his liability. Merely challenging so-called notice and humble submission, it is not maintainable.
Yes. Give your short notes.
In the previous case, I have filed the counter. In this case, I will file a short note.
Permit me to take the status of my proceeding, state proceeding, Your Lordship. So for the status of investigation till date, Your Lordship. So I may be permitted to submit that status.
Submit?
My lord.
The state GST.
No, do it today. We will fix it for judgment on. We can do it by tomorrow.
Your Lordship.
It's a very simple matter.
Your Lordship.
3 days time, Lord. 3 days time.
Simply, because I'm slightly unwell today.
My lords.
Let it come on Tuesday. I will deliver judgment.
Great.
My lords, to clarify my friends.
Yes. Please.
My lords, I have appeared before the summoning officer. My lords, page 99. I filed detailed objection that this is pending before the state authorities. So let me continue there, or either way, my lords. There cannot be two parallel.
See, either you want an adjudication from this court, or you may seek
No,
liberty
my
to
lords.
approach them.
My lords, I am submitting two judgments.
No, what
One
happens
of
when
this
you-
honorable court.
When you approach the authority and file such a petition that similar matter is pending.
Yes, my lord.
What is the order passed?
My lords, he says that he has given specific findings on that. The officer says, since this cause of action is little different to that cause of action, my lords, that cannot be. My lords, it is an investigation and adjudicating process for a tax period, my lords, finance period.
Period is different from the matter. Therefore, we are saying that if you want an order from this court, you will have an order based on what is.
My lords, kindly see
If you
two
want to
judgments,
pursue-
one of this honorable court and another
We will see
by.
everything. We will see everything. Give. Please give.
And this is by the division bench of Calcutta High Court, my lords. My lords, for the very same period, there cannot be two proceedings, my lords. It may be conflict of judgments, my lords. For the very same period, suppose he disallows.
That is not barred under subsection B of section.
My lords, that is why, my lords, I have given the circular in clarification of 2B, my lords, 6-2B, my lords. This circular, my lords, is quoted in the judgments. I have given, handed over, my lord. That is clarification to section 6-2B, my lords.
Where is that?
I have given, my lords. I have handed over, just now. And it was relied upon by this honorable court and the judgment was given that there cannot be two parallel.
Which particular paragraph you just want?
My lords. Para 3, my lords.
It's 3.
3, my lords.
Yes.
My lords, it is accordingly clarified that the officers of both central tax and state tax are authorized to initiate intelligence based in enforcement actions on the entire taxpayer payers base irrespective of administrative assignment of the taxpayer to any authority. The authority which initiates such action is empowered to complete the entire process of investigation, issuance of so-called notice, adjudication, recovery, filing of appeal, etc., arising out of such action. In other words, if an officer of central tax authority initiates intelligence based on the enforcement action against the taxpayer administratively assigned to state tax authority, the officers of the central tax authority would not transfer the said case to its state tax counterpart and would themselves take the case to the logical conclusions. Similar position would remain in case of intelligence based on enforcement action initiated by the officers of the
Sir, how do you submit that in place of matter as mentioned in clause B of section 6, period should be read?
My lords, kindly, the judgments I have given basing on this circular.
So please refer to that.
Ma'am.
In the circular, it is not clear. Is it clear? No.
My lords, what I humbly submit, my lords, it is adjudication assessment for a particular tax period, my lords. Suppose there are 10 transactions taken over by the state authorities. They allow 3 transactions. And state of the central authorities passes something different order. My lord, it will be conflict. It is the purpose object is that.
Mr. Therefore, in the wisdom of legislature, the expression matter was found to be more appropriate than what you are suggesting, period.
My lords, my humble submission is that it is always period. My lords, another kindly visualize, my lords. Suppose, my lords, another authority, central authority from another state finds a particular incriminating documents. He will proceed another for that very period. It cannot be. That is why the circular is that it is
for that particular period. Different type of matter can be initiated,
my lord,
against you, which has been done in this case.
My lord,
so you cannot say that.
My lords, all the things should be taken by one authority, my lord, that is the law.
We will examine that. What is the law, we will see.
My lord.
We will
My lord,
decide.
two judgments I have given, one by the Calcutta High Court, by this honorable court.
Yes.
There cannot be parallel proceedings for a very same period.
Same period. Where is that expression? This is what you want to see.
Your lordship may fix to.
Why fix?
They
You have two judgments.
Yes, my lord.
It's just thing.
This aspect I can clarify, my lord. So period, so far period is concerned. My lords, it is, my lords, what I humbly submit, my lords, for a particular month, suppose 4 authorities.
Please don't cite example.
My lord,
Understand what you have submitted, we have understood. Our duty now is to interpret section 2B. Section 6.2B.
6.2B.
Section
My lord,
section 6.2B of the Act, and your challenge to the notices.
Read with this circular.
All right, we will read that with circular and 2 judgment which you have cited.
My lords, in Calcutta High Court judgment,
Yes.
the period was
We will see.
very same period.
See, the Calcutta High Court judgment does not bind us.
No, my lords, it has persuasive value, my
We will
lords.
see.
And this, our High Court judgment, your lordship will see.
That we have seen, the period is not there. We will examine, Mr. Counsel.
I'll file a short note by.
I will file also.
As you
One
wish.
short note.
So, because you are not, you are still on your point that you want to challenge the notice itself. All right. Heard learned counsel appearing on behalf of the parties list these matters on Tuesday for judgment.
You take tomorrow.
Tuesday next.
We'll file short notes in the meantime.
As you wish.
Item 12.
Lordship, in this item number 12, it is an income tax matter, your lordship. Your lordship, this matter what I pray, your lordship, I kindly adjourn after 1 week, your lordship, next week at least. Your lordship, I have to take one.
All right, as requested. On behalf of the petitioner, list this matter on. 2 weeks.
Your lordship, please, just one prayer already they have already granted. One prayer is infructuous. So perhaps the other prayer I have to take instruction, your lordship. So 1 week after.
Yes, next. 2 weeks.
Your lordship.
Item 13.
Your lordship, please.
May I please allow? It is a PIL lordship. The petition is the inhabitants of Daspatra village lordship under the Gondia block of Rekanagari district lordship. The grievance of the petitioner that the village of the petitioner is connected in the 2 blocks. One block is the lordship Gondia block of the Rekanagari district, as well as connecting to the headquarters of the Dharmasala block of the Jaspur district lordship. And connecting the 2 headquarters of the block, the present petitioner's village has 3 roads, RT road. And during the rainy season lordship, that road lordship, interior forest area covering that road lordship, that is submerging some portion of 3% of that road lordship. And every year the villagers, the students, the business persons, they have been disconnected from the headquarters of the block. Every year, lordship, in the rainy season, due to heavy rain waters as well as the flood waters of the river Brahmani, lordship. And
So what do you want?
Since 2020, lordship, the petitioner as well as the villagers, they are.
What do you want?
My lordship, they have approached the authorities, lordship, to these 3 places, lordship, where the submerging the work every water.
What do you want?
The petition villagers wants to approach the authorities.
Approach, may approach.
construct the culvert or bridge over
Culvert.
that
You
places.
So just a minute, you
Yes.
want construction of a culvert.
Minus culvert or bridge over that particular places, Your Lordship. By the process, the problem of the inhabitants, they will
Area which inhabitants of which place?
that, Your Lordship, Daspatna village under the Gondia block of the Denkana district, the petitioners resides Dasman Patna, Your Lordship.
Dasman Patna.
And Gondia.
Gondia district, Your Lordship, Denkana. Now, Your Lordship, there is a proposal for construction of road, Your Lordship, under Annexure 1.
Yes.
So, if Your Lordship direct the state authorities to take instruction regarding whether they are constructing the bridge in covering this proposal for road or not. Only that instruction, Your Lordship, may
Tell us what are we?
My Lordship.
Exercising jurisdiction under Article 226, what are we? According to you, they are constructing some road.
Yes, Your Lordship.
Now you want us to issue some direction.
No, my Lord. Yes, sir. As per after Annexure 1, Your Lordship, the approval for construction of the road, Your Lordship, the present petitioner acts under RTI to the constructing authorities, the engineering chief of construction, whether after constructing
We are
this.
making it clear
This,
that we will not depend upon and we will never rely upon the informations which you receive under the Right to Information Act while adjudicating any matter.
Managers.
So don't refer to RTI.
Yes, Your Lordship. The authorities clearly stated that so far the submerging the particular places in the road, Your Lordship.
Mister, your submission is that a culvert is required.
Yes, Your Lordship.
For connecting two villages or two places.
My Lords.
That is in public interest. This is what you want.
My Lords.
This is what you want.
Yes, Your Lordship. That is the grievance.
Who are you? Who is your client?
I am the one of the villagers, Your Lordship, Daspatna, the affecting person, Your Lordship.
And where is your Sarpanch or Mukhia?
They have also repented, Your Lordship. They have also repented, but the repentations I have annexed, Your Lordship, Annexure 5 series and Annexure 7 series.
So this is your simple prayer that there should be a culvert.
Yes, Your Lordship.
That's all.
My Lords.
Nothing else.
No, my Lords.
And because there is a water body in between.
Yes, Your Lordship. 3 places, Your Lordship, water board lodging every year, Lordship. Lordship, these 3 places should be under a culvert or bridge, whatever the requirement is there, Your Lordship. That is the grievance
They
of the.
know it better. They know the situation better. So which are the villages? Which are those villages?
The villagers are I have given under Annexure 5. Under Annexure 5 series, Your Lordship.
Disposing of the
34, page 34.
Consider the petitioner has filed the present writ application in the nature of public interest litigation with a plea that the authorities may consider constructing culverts between the villages mentioned in the writ petition, as according to the petitioner, during the rainy season, the area gets waterlogged and movement of the villagers restricted. Stop. There is a statement made in the writ petition that the villagers of the concerned village had approached the which authority?
Which collector Lordship OP 4 and 5, both the collectors, Denkana and Jaspur Lordship.
Approached the concerned collectors
OP 4 and 5 Lordship. Collector of Denkana district and Jaspur district.
Denkana district and
Jajpur district.
Jajpur district. In this regard, but nothing has happened till date. Full stop. This court, exercising a writ jurisdiction under Article 226 of the Constitution of India, does not have the necessary wherewithal to conclude that a culvert at a particular place or places is required or not, comma, in public interest. Required or not in public interest without comma. So stop. It is up to the concerned authorities to take a call in such matters. So stop. In view of the clear stand taken in the writ petition that the petitioners had approached the authorities, this application is disposed of with an observation that let the district magistrates of the districts of examine the requirement, comma, feasibility and viability of construction of culverts at the places mentioned in the writ petition. So stop. We have not gone into the merits of the case, which we make clear. Stop. This writ application stands disposed of accordingly. Observation has been made in the light of the submission advanced on behalf of the petitioner that the representation so made has so far not been considered and disposed of.
Number 3 is Union of India, it may be ignored because we don't have a rule. OP number 3 is Union of India, they implemented.
It has been rightly pointed out that Union of India has unnecessarily been implemented as party
OP
respondent.
number 3.
As opposite party number 3, let the name of opposite party number 3 be deleted from the cause title.
Item 14.
May I please, your lordships. My lord, the petitioner being a 50% partner in a partnership firm had made an application to be considered for a contract job. Now, my lord, as per qualification, appearing at your lordship in order to qualify, my lord, may kindly turn to page 31. 2.1.5.
No, what do you want?
I want, my lord, my qualification as a partner is not being taken into account when I am individually tendering for the job. In the process, I can never compete in any government contract.
It can happen.
Whereas in similar instances, other tenders, they always take the percentage of my share in the partnership firm as my qualification, my lord.
This is up to them.
That is true. But this is what I am agreed to. I can never work, my lord.
May not. You do something else. But the court cannot say.
Yeah.
Unless you demonstrate that your any legal or constitutional right has been infringed, this court cannot interfere.
Other than right to livelihood, I can't say further. Because this cannot by itself. Your lordship is always right in saying, and I also am conscious that they can put forth the tender condition.
What is your worth?
My lord, construction of road.
What is your worth? How rich are you?
I don't know. In my partnership firm, I'm quite rich.
But you are quite rich.
In individual 5 crores or something.
And your you don't have any
Individually, I have,
livelihood.
I have no worth. Individually, I have no worth.
Usually you can find some alternatives. You have money, you have resources.
That is the small.
It's a policy matter.
My lord.
It's a policy matter, Mr. Contract.
All true, my lord, but where do such a person goes? That's the problem. Because they have rejected my representation, your lordship, taking that plea only at page 16. Hence, due to the work experience and financial turnover of a firm may not be considered as your own, because the said experience and financial turnover goes in favor of number of partners in the firm of Mrs. Nilachakra Construction. Nilachakra has 2 partners. I am one of the partners. I was claiming 50% of that.
Yes.
So in appropriate cases.
Sorry. What do you want?
So if your lordship is not inclined, in appropriate cases, my liberty may be granted. I may
counsel for the petitioner, after some argument, seeks permission to withdraw this application with a liberty to raise the point raised in the present writ application before in appropriate case. The application stands disposed of accordingly.
Item number 15.
My please, your lords. My lord, reimbursement of enhanced royalty, your lordships. Here is a case, my lord, under the 2004 rules, 2 enhancement was challenged by this honorable court, and this honorable court declared the unlawful that enhancement straight before an SLP, my lord, which was dismissed by the honorable apex court. Thereafter, state made a scheme that it will be reimbursement. As per the order, the executive engineer issued a terminal certificate, and if it is lying with the executive engineer, then will directly return to the reimburse to the contractor. And if it is deposited in the revenue, the Tahsildar will the refund. Here is a case, my lord, it was already deposited before the Tahsildar, and the executive engineer issue a certificate to release in his favor. The Tahsildar is not, my lord, reimbursing the same. An identical issue, Lord, your lordship's got 2 coordinate means please to pass an order. I have annexed that, page 31 and 32. Direct to the certain period, your lordships. The Tahsildar to release the enhanced royalty amount within a stipulated period. Page 31, 32 is the 2 orders I have filed, your lordship.
Yes. Yes, state.
It's my disposal.
Right.
Because he has already, the lordship can see page 28, my lord.
Yes.
Tahsildar has already paid an amount of
we have another question to ask. Why has he come to the court?
My lord, for the refund of...
Why was he compelled to come to this court?
Lordship can page 28, my lord. The Tahsildar has already refunded a sum of rupees 1,77,000.
Yes.
And he's submitting the more, my lord.
No, my lord, my lord, is incorrect, my lord. And page 28 is the letter of the certificate issued by the executive engineer to the Tahsildar. Your lordship can have page 28. That he has...
Last para, my lord. The Tahsildar has already refunded an amount 1,77,604, my lord.
No, in page number 29.
My lord. Further recommended that
Right.
by the...
So the question which was asked
My lord, my
by the Chief Justice, that why this gentleman came to the court.
No, for that, my lord, I have taken instruction, my lord. What happened, my lord? Because this is a letter, my lord.
All right. For that purpose, we may adjourn it.
My lord.
And if you are not satisfied with your action, then in all such cases, we will be imposing exemplary cost.
Well, I will take instruction, my lord, in this regard.
Because in the meantime, 3.5 years have passed.
My
The
lord.
order is dated 12.
2020, my lord, I am our, I'll take instruction on this.
But
This is,
but in
this has come first time,
If you would have got that money at that point of time,
my lord.
he has been deprived of for 3.5 years.
Now, this has come
Which
first
to
time, I'll
pay
take
interest.
instruction, my lord. I'll take instruction, my lord. What happened?
Put this case on 1 week. Tuesday then, so as to enable and state council to inform this court as to why the refund which the petitioner has been held entitled to, a refund of the amount which the petitioner has been held entitled to under later dated 12/8/2020 issued by the executive engineer, Jajpur Irrigation Division, Jajpur, bracketed Annexure 5, has not been met till date, compelling the petitioner to approach extraordinary writ jurisdiction of this court. Full stop. This matter shall be listed within first 5 cases.
Item 16.
May I please lordship? My lord, I appear on behalf of Himan Shekhar Panda. She has some personal difficulty, maybe adjourn.
How much time?
1 week, my lord.
2 weeks as requested.
Oblige, my lord.
Item 17.
Lord, there are 3 orders.
Three?
There are 3 orders, my lord. One is passed by the
Why
collector.
are you smiling?
No, it's
Either you have a weak case or you have some doubts about the court.
no, my lord. Absolutely, I have very good case.
Yes. All right.
With a good
That
point
was
of law.
on a
my lord.
lighter note. Yes.
I understood. Lord, there are 3 orders.
Yes.
One is passed by the collector, Lord, directing closure of my shop. That order, your lordship will kindly find at page 15 of my brief, my lord, a neat type copy. Lordship got it, no?
That is annexure.
That is annexure 2, neat type copy is at page 15.
Annexure 2 is under challenge.
3 orders are under challenge.
Yes,
Annexure 2 is the
annexure
first
2.
order.
Annexure 2 is page 14.
Page 14 is the original order. Neat type copy is at page
That has
15.
been typed.
Right.
Oh. Yes.
Lordship will see in exercise of powers conferred on section 26 of Odisha Excise Act 2008, the Marine Drive IFL op shop functioning at Mouda so-and-so, ward number so-and-so is hereby ordered for temporary closure after sale hour 8th of January 2024 for preservation of serious law and order situation. Then this order is approved by the collector and I'm sorry, Commissioner of Excise, that is annexure 1. Then immediately on the same day, Superintendent of Excise writes to me that you shift this shop to another location. Am I clear, my lord?
Yes.
Now, your lordship may kindly see, before I take to any other aspect of this case, my lord, kindly see section 26, my lord, of Odisha Excise Act.
Where is the shifting one?
Shifting is third one, my lord, annexure 3, that is at page 17. Collector there has absolutely no jurisdiction to direct shifting because it is subject to approval by the commissioner. Now, kindly see before that, section 26, my lord. The lordship's got it, my lord. The district magistrate
Section 26 of the Odisha Excise.
Odisha Excise Act. The district magistrate or a subdivisional magistrate may, by notice and writing to the licensee, require that any shop in which an intoxicant is sold shall be closed at such times or for such period as he may think necessary for the preservation of public peace, provided that if the closure is required for a continuous period of more than 3 days, approval of the excise
You are
commissioner.
reading which section?
Lord, I am reading section 26, my lord. I'm sorry,
Please
Lord.
read it again.
I'm so sorry. I'm so sorry, Lord. Lordship, please. I've not got it. I'm so sorry, Lord. Section 26. Lordship got it, Lord.
Yes.
the district magistrate or a subdivisional magistrate may, by notice in writing to the licensee,
Yes.
require that any shop in which any intoxicant is sold shall be closed at such times or for such period as he may think necessary for the preservation of public peace. The catch here, Lordship, will get is with a notice in writing. That's the catch here. The collector abruptly passes an order, you close it down.
That is the notice.
No, it's a closure order. It's a closure order. Straight to a closure order.
That is the closure.
Not with a notice. He must give me a notice prior to this.
No. It's not notice means communication. That communication may be in the form of.
That is what is interpreted in the way by our own High Court. If a Lordship will kindly consider that.
No, because once it is a question of public peace, it requires.
I'll take your Lordship.
This notice,
I'll take your even
this notice, Mr. Senior Counsel, cannot be considered to be a so-called notice.
Not that is the interpretation by this honorable court in this judgment. Sarvadil. Kindly see Lord para 6 of this judgment which I have given. It's an order. Sorry. Yes. Para 6. For the impugned order, that's got it. For the impugned order, it also appears that Collector Puri has passed temporary closure order in exercise of power.
No, just a minute, Mr. Rotho. This the honorable judge has dealt with that Bihar and Odisha Excise Act.
Not the same provision, perimeter provision. Earlier it was Bihar and Odisha. Now it is Odisha Excise Act.
Just let us be satisfied.
Same section.
Section 26(1) of the Bihar and Odisha Excise Act. Whether it is same or there is any change.
Same, Lord. If my instruction goes, it remains same.
Bihar and Odisha Excise Act.
Purna Bhai.
No, it's very difficult.
Lordship got that judgment, man?
Yes.
Kindly see para 6 months.
Yes.
From the impugned order, it also appears that Collector Puri has passed the temporary closure order. Lordship got it, man? In exercise of power under section 26(1) of Bihar and Odisha Excise Act 1915. Section 26(1) of Bihar and Odisha Excise Act reads as follows. The same provision here.
Yes.
Provision is quoted here. Lordship need not even go to that other book.
Right.
Provision is quoted here. From the above, this court finds that there is a serious legal flaw in the action of the collector. Since section 26(1) clearly postulates a notice in writing to the licensee under the circumstances of any intoxicating is sold before temporary closure of such shop, and further if a closure is required for a continuation period for more than 3 days, approval of the excise commissioner shall be taken. Compliance of natural justice is a compulsion. The impugned order has been passed not only in improper consideration, one second, my lord. Required for 3 days, the approval of the excise commissioner shall be taken. Compliance of natural justice is a compulsion. The impugned order has been passed not only in improper consideration of the protest available on 6, but also being contrary to the provisions contained in 26(1), the same.
So any view, Mr. Senior Counsel,
right?
Any view which has been taken to the effect that any the principles of natural justice is required for temporary closure under 26.
Correct.
That view cannot be accepted. And if that is the view which has been taken, we may differ and may refer to larger bench.
Lord, I have other points. Lord, besides that, Lord, keeping that point in issue for adjudication, I have other points. Kindly consider my other points also. Now, Lord, this is a saw continuing since 2021.
No, the power under section 26 has been exercised in your case.
Right, my lord. And this is a saw existing since 2021 continuously, without any protest, without any objection. In a fine morning, this National Congress people, they came and submitted an objection against this saw. But I have today a material, this National Congress, in front of this National Congress office, in front, One shop is
We
operating.
will not go into that.
But that your lordship.
That power under section 26, which has been conferred upon the collector, is an emergency provision.
But I'm saying, I'm coming to that, Lord. The inquiry report is there. Inquiry report doesn't speak anything of law and order, disturbance of peace. An inquiry report is there. But there must something must be borne out from record that there is an emergent situation, a law and order situation, some kind of riot. I can understand that it will be closed.
So whether your shop is closed
Yes,
today?
Today, by what? But it is only at the behest of the rival traders, nothing else.
So we are just trying to understand whether your shop is
Closed.
still closed.
Closed. And your lordship, see the inquiry report doesn't speak
When
of.
was the order passed?
Well, it was passed on 8th of January 2024.
8th of January 2024.
Correct, Lord. By this time, they should have reopened it because the good extent of period has already lapsed. And your lordship will see inquiry report doesn't speak of any law and order situation. And in front of these office people, there is a shop operating in front.
This power is extraordinary.
Correct, my lord. But that is for a limited period or any further period. That's okay. But then the report, kindly see, my lord. The report doesn't speak of any riot, any kind of something like that.
No, we don't know.
But that's there, available on record.
The district magistrate says for preservation of public peace.
That's right.
So he may be apprehending even.
But there is a report.
When in case of apprehension, breach of public peace.
But they have inquired into their grievance. I mean, it is nothing on apprehension. Some group submitted a grievance against this shop. Collector suddenly closes it. That's all. The inquiry report, page 35, if your lordship says on that grievance itself, an inquiry was taken up by the excise authorities, my lord. And there is nothing. There is nothing of law and order.
And where is the approval of the excise commissioner?
But that is annexure 1. Page 13. And by now they should have updated themselves whether the situation still continues or any, because I am bound by MGQ, license fee, huge. Seven one is the objection, 8.1 is the closure.
Yes, what is your submission? State.
Here, in exercise of power under section 26, annexure 1 and 2 has been issued, and that has been approved as required under the subsection provided to subsection 1 of section 26. But thereafter, since there was an apprehension of law and order situation, so that's why the closure direction was issued, and accordingly the petitioner was also requested to change the site to an unobjectionable site. Whether what steps have been taken pursuant to
Objectionable site means what?
unobjectionable site.
Unobjectionable. In the
That is
type
annexure.
copy, it is mentioned objectionable.
That is annexure 3. Page 17. No, I'm so sorry.
Read your.
I'm so sorry.
Read your annexure.
Right. That is
Second paragraph.
Shifting. Yes, my lord. Annexure 3, page 17.
Second paragraph of that order.
Right, my lord. You are hereby instructed to find out an unobjectionable site and apply through online for shifting of your
Please
premises.
read that paragraph again carefully.
You are hereby instructed to find out an objectionable.
Yes.
That should have been unobjectionable.
So,
I'm
yes.
so sorry, Lord. I am so sorry.
I was also
I beg
surprised
apology. I beg apology.
That what kind of this?
Here original also objectionable. I'm so sorry, my lord. I'm grateful, my lord. Lordship.
All right.
I'm so sorry. Sometime, my lord,
It happens.
it happens. Still, your lordship.
Mr. Is there any averment you have taken that there was no such law and order?
Yes, my lord.
situation
Yes.
Which compelled the
Yes, my lord.
director to pass such an order?
Yes, my lord. Yes.
So whether affidavit has been filed in this case?
Yes, my lord. And we have complied.
Coming for the first time.
We have become careful, man.
No, either affidavit. Let counter affidavit be filed.
Yes, my lord.
2 weeks time is allowed for, how much time? 2 weeks?
2 weeks.
Time is allowed for the state to file, state opposite parties to file counter affidavit. There's this case on 3 weeks, 4 weeks. Time in the meanwhile may be utilized by the petitioner to file a rejoinder, if so required.
Interim I have prayed for, subject to.
Interim, there is no
It
question.
is already closed, your lordship is proposing, my lord. But then if closure continues, my lord, I'll be.
We will see if the closure continues
Consequence, your lordship will continue.
even on that day, then we will presume that that was not an order passed under section 26.
26, absolutely.
You understand why? Because that law and order situation, according to the collector, is continuing. For
You can go to the collector and show this order in the annexure 13. So according to you, it is an objectionable site. And the excise superintendent has said that I have to open it an objectionable site. So allow me to function.
yes.
So grateful.
Item number 18.
May I please, lordship? My specific prayer is my page 21 is pending before the Tahsildar he has not given the opportunity to adduce my reply because some of the villagers who has given alleged allegation against me by annexure 2 regarding sale and purchase of the government lands. After receiving the said allegation by the public, then sub-collector issued one letter to Tahsildar Dhara Court on 2/11/19 to inquire into the matter. Thereafter, by annexure 3, page 17, Tahsildar issued a notice to me to appear on 7/6/23 to adduce my reply. On that date, 7/6/23, I filed my hajira before the Tahsildar, but Tahsildar didn't give me opportunity to adduce my reply. Therefore, I filed one application before the Tahsildar at annexure 5 at page 21 to give sufficient opportunity to adduce my evidence as there are allegations against by the villagers against me regarding selling and purchasing of the government lands.
This writ petition was filed on?
This is the second litigation. First one at page 14. Some documents I have not given to the honorable court. That is why I filed the second writ application here. I filed one second. I filed. Annexure 3, page 16, Annexure 2, page 16 is the collector letter regarding allegation of the petition received from the villagers to conduct an inquiry. Thereafter, page 17, by Annexure 3, Tahsildar reported me.
No, in the earlier writ petition.
Yes, ma'am.
What is that annexure 4?
I have an annexure, that is at Annexure 2, page 15. I have not given that annexure in earlier writ application. That is
What
why
is the matter pending before Tahsildar?
Yes, ma'am.
What is the matter pending?
Matter regarding the villagers has given some compel allegation against me regarding selling and purchase of the government lands to other people. That is the allegation made by the villagers. Then sub-collector issued one letter to me to conduct, sub-collector issued a letter to Tahsildar to conduct an inquiry.
Yes.
Thereafter, Tahsildar fixed a date to appear before the Tahsildar on 7/6/23 at page 17.
Then,
I appeared there on 7/6/23.
then,
Tahsildar did not give me opportunity to adduce my reply. That is my case.
you should be happy if they finally takes a decision against you. You can challenge that decision on the ground that you are not given personal hearing.
Yes, I will appear there.
Then why this? Why? You should be given personal hearing. You should be allowed to sit in his office. You should be allowed to file your representation.
Yeah, I filed representation on Annexure 5.
All right.
Page 21.
Necessarily,
His prayer is here to cross-examine the persons who had raised objection.
we will regulate here.
My lord,
We will be regulating here the proceeding before Tahsildar.
I will appear there. I will file an
Go there, whatever you want to do.
Yes, ma'am.
From the pleadings on record, it transpires that certain proceeding is pending against the petitioner before the Tahsildar Dhara Kota Ganjam based on certain allegations made by the villagers regarding fraudulent sale of lands. Stop. The petitioner wants this court to issue a direction to Tahsildar to give him an opportunity to cross-examine the persons who have approached him against the deeds of the petitioner. Stop. In our considered opinion, this writ petition is not only misconceived, rather frivolous. Stop. It deserves to be dismissed at the threshold and is accordingly dismissed. Stop. It goes without saying that if any decision of the Tahsildar grieves the petitioner, he shall have liberty to approach appropriate authority in accordance with law.
Item number 19.
May I please, your lordship? Your petitioner is a licensee in respect of Indian-made foreign liquor off in the district of Baleshwar, my lord. Lordship, kindly peruse the Annexure 1 at page 12.
Yes.
His license is still valid, my lord, 31st March 2024. That is the excise year 23 and 24, my lord.
Good.
Lordship, see the column, it has been written MGQ details. The MGQ means, my lord, minimum guaranteed quantity.
Yes.
Every license is required to leave the monthly MGQ, that is beer as well as liquor, my lord. Lordship, may see in the block MGQ in BL. This is a beer, my lord. Bulk liter, that is beer, 4,472 liters, 0.20. He has to leave every month. Then, my lord, second column, MGQ in LPL, London proof liter, that is in case of liquor, my lord. He is required to leave every month, that is 2,851.2 liters, my lord, every month. This is the conditions he is bound to leave every month. But what happened last 3 years? Due to COVID-19 situations, there is less sale of liquor and beer in different area. It varies from one area to another. Here, the Baleshwar district, my lord, it has come to the notice, my lord. The people are more fond of drinking beer instead of liquor. So what happened? The licensee has lifted more beer and he has just failed to target the MGQ of liquor. So he has prayed to the government, to the commissioner, to give a scope for interchangeability, whatever excise duty he is ready to pay, but only for interchangeability of liquor instead of beer. That is Annexure 4, that is penny before the government. Government is the discretion, my lord, he has to consider, my lord, because my license is till 31st March 2024. Within that period, he has to clear all the MGQ, otherwise the shop will close, my lord. No, there will be no renewal of license for the next excise year. So that Annex 4 is pending.
Yes.
Also,
And
what-
direct for disposal, but there is no such provision. I was checking.
No, I have told that is the
There is no
discretion of
such
the government.
provision.
No, where is the provision? If
There is no provision. There is no provision for relaxation. Only we have prayed, my lord, that before to the government to give some exemption, but only interchangeability.
If there is any provision under which
Provision, there is no under provisions of the, my lord, Act.
we are
That
very
Annex
happy that
4
we have been very fair in your submission.
My lord, what happened?
Yes.
Just one day before your lordship's joining, one order has passed and direction given to commissioner to consider. So Annex 4 is pending. We have prayed for interchangeability. We are ready to pay the government duty because there is no loss to state exchequer.
You may be, you may approach, you may do whatever you want.
That
we will not.
That Annex
ask them.
4, only my lordship may see my prayer.
Had there been some provision under which they were required to
Lordship may
consider-
see the Annex 2. Annex 2.
Yes.
Lord's, my lord, page 14.
Yes.
This was the order had government had taken a very lenient view. Lordship, may I read, my lord? A number of representations have been received from the retail license of the excise shop regarding a difficulty faced by them in the meeting of the MGQ quota for the year 2021-22 due to disruption in sale owing the second wave of
So
COVID-19.
this is for the year 21-22.
22, my lord.
Your case.
Yes, 2023. Then Lordship may see the next order of this honorable court.
Sir, your case is covered by 21-22.
All together, Lordship, that's why I'm taking Lordship's attention to Annex 3.
Yes.
Also, 23-23, we have faced the same problem, my lord. By virtue of this honorable court order, government has allowed 21-22, 23-23, all the short-lifted MGQ will be lifted in 23-23. Lordship may see the Annex 3, the relevant portion of the order, Lordship may see. It starts from page 17, but the operating portion, my lord, page 18, para 5. In
No,
view of
this is
such
different.
position, this court disposed the
This is
writ petition permitting the petitioner to deposit the requisite fees along with the statute fees for running of the shop or renewal thereof, and whatever shortfall MGQ are there for the previous years, 21, 22, and 2023, the same shall be spread over for the excise year 2023, along with the MGQ of the current year. So, in view of this, we are bound to lift.
This was for renewal only.
And also some relaxation was given. Then government allowed us. Then the license was renewed for 23-24 excise year. So only this year, because we are prayed for interchangeability. That Annex 4 is pending before the commissioner. Because government is, well, state is getting 7,000 crore out of liquor trade. So that is, if, because nowadays it has come to knowledge, well, more than 100 licensee, they're facing the same situations. So there will be no loss to the state exchequer, my lord. Rather, state will be benefited because there will be augmentation of revenue.
Therefore, we are not restraining them for taking any decision.
That's the only, my lord.
But we cannot direct them to take a decision on a point which is not there under law, on the issue which is not there under the law.
Section 90 the empowers state government to make rules. 91 also not explicitly provides, but by of notification they can pass anything, my lord. Because large repetitions are pending before the state governments. So only
the petitioner asserts that is exclusive is an exclusive privilege holder, bracketed EPH, of government bus stand, India made foreign liquor, bracketed IMFL off shop at Sarthe Bazaar, under Sartha GP area in the district of Balasore. Full stop. He made a representation
To Excise Commissioner Odisha, my lord, OP number 2.
to the Excise Commissioner Odisha on 3/11/2023.
Yes, my lord.
On 3/11/2023 for interchangeability of the short downfall, short drawn IMFL into beer for the excise year 2023 to 2024, mainly on the ground that the consumption of beer has increased and consumption of
Liquor has less demand.
consumption of what you call it, liquor.
Consumption
What is there in the document which you are reading?
Consumption, IMFL, liquor.
Consumption of IMFL has gone down. So stop. Interchangeability of MGQ.
MGQ of IMFL, liquor.
MGQ
Into beer.
All right. MGQ of IMFL into
beer
on the ground that consumption of beer has gone up and consumption of liquor has gone down. Full stop. The petitioner is seeking a direction to the Excise Commissioner to consider his representation
at Annexure 4.
Consider and dispose of his representation expeditiously. Stop. Next, learned counsel for the petitioner has not been able to point out from the statutory provisions as to whether the Excise Commissioner has such jurisdiction. Excise Commissioner or state government has such jurisdiction.
State government has jurisdiction.
Huh?
State government has jurisdiction.
We have mentioned start. You have not shown us such jurisdiction. In such circumstance, we decline to issue such direction. So stop. Next. It will open, however, for the petitioner to pursue his case, and it will also open for the authority to take a decision in accordance with law in this regard. Application stands disposed of.
Next item, my lord, same annexure, same, only date is different. Area is different.
Area we have not mentioned.
District is the only difference. Here district is Raigada.
Item 20.
Same.
Item 21.
Lordship, in this matter only, I am challenging a decision in passing a order of termination without giving me, Lordship.
Is the affidavit in order?
Yes, Lordship. I filed it in order, Lordship. Lordship, straight I come to page 188. Here is decision by a committee, Lordship, terminating my contract. And a subsisting contract has been terminated without giving me either reasonable opportunity of hearing or, Lordship, relying upon a wrong provision, which is contrary to their own terms of contract, Lordship.
Then you could have invoked the arbitration clause.
In fact, Lordship, kindly see, because I am intending to complete the work, Lordship, because during the period of contract, Lordship, kindly see what the peculiar order they have been passed.
They may be intending to complete the work. They may not be willing to take your work.
Because, Lordship, my repentation is still with them, despite this order. Lordship, because this is a wrong provision. This order has to go, Lordship, because Lordship, kindly come to Lordship, page 180, Lordship, for a moment.
The order will go how?
Because, Lordship, they have mistaken the provision, Lordship. Lordship, because if Lordship will interfere, Lordship, then.
You are acting as.
No, Lordship. Never, Lordship. I just am pursuing Lordship. I am requesting Lordship because here is a case to be interfered with. That is my only humble submission. Lordship, kindly come to 188. On the face of it, Lordship, it is per se illegal, Lordship. Page 188.
Eight.
188, Lordship. 88, Lordship. 188. Package number 17, Lordship. There is a in between. This document starts from page 176, Lordship, and my operative part, Lordship.
188.
188, Lordship.
Yeah.
Lordship, package number 17, Lordship, in between.
Yeah.
Lordship, there is my name and my package number. Just I'm reading the paragraph, Lordship. The CC RW Circle Sunabada has submitted termination proposal recommending to terminate the contract in view of slow progress of work by letter number 9/1/2024. So-called notices has been issued to the agency by Superintendent Engineer RW Division 1 Navarampur by his letter number such as they have given number of references. Then Lordship, next sentence. The agency had abandoned the work since 15/12/2023. Lordship, this date is very important, Lordship. As per the report of a Superintendent Engineer, the agency is not responding to the notices and phone call of the officials and also not taking any interest to carry out the work. Provisional EUT has been given to the agency by PIU up to 31/1/2024. The CC and executive engineer both have recommended to terminate the contract under clause number 52.2 small a and c of the CGC. Then, Lordship, accordingly, the committee has recommended, the committee unanimously decided to terminate the contract under clause 52.2 small a and c of GCC, that is following the due procedure as per SBD, the liquidated damage is applicable to the initial contract price for delay of 20% penalty of the balance work should be imposed as per the relevant clause SBD. The AC should take necessary steps as per the codal provision to terminate the contract. So it is yet to be terminated and they have taken a decision and given a direction as per clause 52.A, the work has been terminated. Then Lordship, kindly for a moment, Lordship, come to the provision itself, Lordship. The provision appears, Lordship, at page.
Which provision?
Lordship, the 52.A, Lordship, of the GCC, General Conditions of the Contract, Lordship.
That is regarding what?
That is the terms of contract, Lordship. Relying upon such provision, they have taken this decision, Lordship.
Cannot go into this.
Lordship, my work abide by the terms of the contract, Lordship.
Terms of the contract, we cannot go into. There is arbitration clause.
No, Lordship, I am not on the Lordship. I want to, Lordship, conclude the work. Only my humble submission for Lordship. Because taking a decision, had it been reasonable opportunity given to me, then matter could have been lordship settled there, lordship, because there is no intention to abandon the work. Lordship, that section itself speaks of lordship. So lordship kindly see, I am showing my bona fide lordship, kindly come to Annex 13 series. Immediately after, I have approached before the authority with an affidavit. I am doing the work and I want to complete the by this month, by 2 months, lordship, I will complete the work. That undertaking with the authority at Annex 13 series. So that's a lordship. Lordship for a moment kindly come to clause 52.8, that is 8. Lordship, page 113. Lordship, 52.2a speaks of lordship. The contractor stops work for 28 days when no stoppage of work is shown in the current program and the stoppage has not been authorized by the engineer. So they have not resorted to 28 days. Lordship, kindly the dates they have given. Within 15 days, lordship, as per their own letter, in contact with their own provision, they are relying upon, they have terminal contract, they have passed this order. Had it been a case, lordship, I could have been, lordship, issued notice to have a say, lordship, before the committee, and the committee also not authorized. Now the committee has given direction to issue termination, lordship, procedure. It is yet to be. So, lordship, if lordship will peruse the entire terms of the contract and the provision of law, this is not permissible in the IF law. So, my humble submission.
How many notices have been issued against you from 2022?
Lordship,
because of the slow progress of the work.
Lordship.
So how do you say that?
Lordship, that is that for that also there is a valid explanation for me, lordship, because this is works pertinent to tribal area. The tribals have encroached upon the land. So Lord, they are not leaving the land, lordship, for construction of road. That's why, lordship, can see there is a clause under the contract, lordship. Within 15 days, they have to hand over the site. They could not hand over the site to me for the reason that they also extended the work to complete the till. That is borne out record, lordship. Lordship, that's my humble song before lordship. Annex 13 series pending with them. Let them obtain instruction only, lordship. My dependent with them. If they will permit, I will complete the work. I am doing, lordship. Still I am.
How can you complete the work?
Lordship, they have till that they have not terminated me, lordship. I am doing, lordship. This is a only notification. They have directed to initial proceeding. They have not terminated my contract, lordship. Still I am working. Mature anticipated, lordship, if they will not consider my application under 13. No, lordship. If lordship, my representation under 13 series not be considered, then lordship, it will be, lordship, I anticipate, lordship, it will be infectious. If they will consider my under representation on 13 series, then lordship, nothing will remain to lordship decide, lordship. It can be suffice, lordship, if they will consider my representation on 13 series, because immediately I have approached. And the decision itself is contrary to their own provision of law, lordship. They have enacted the law, and this is under the GCC, lordship. They cannot follow their own terms of contract, and they have given the figures. The requirement is 28 days, and before that, within, lordship, 20 days they have taken the action. If that's true, if their contention is correct, lordship, without giving me reasonable opportunity hearing, and lordship, without qualifying the dates, lordship.
This decision dated 12/1/2024 was communicated to you?
Lordship, this decision, lordship. Yes, lordship. This decision I have obtained, lordship, not communicated, lordship. I have obtained, lordship.
And thereafter you filed a representation?
Immediately, lordship. Immediately I filed representation.
Did they ask you to file any representation?
No, lordship.
What is the decision?
Lordship, decision, lordship, they have given a direction, they have recommended for termination and to issue process for termination process, lordship. Kindly, 180, lordship, last paragraph, lordship. Lordship, the last sentence also, a superintendent should take necessary steps as per codal provisions to terminate the contract. So it is yet to, lordship, page 188, last line, lordship.
188.
Last line, lordship, last sentence. The superintendent engineer should take necessary steps as per the codal provisions to terminate the contract.
Where?
Lordship, page 188, last sentence, lordship, at the bottom of the page, lordship.
Yes.
Lordship, again I'm reading, lordship.
Necessary
Steps, lordship. So it is yet to be terminated, lordship.
What are the necessary steps?
Lordship, they will issue process as per the provision under 52, lordship.
What is the process?
Process, lordship, they issue, lordship, so cause and lordship.
What is this? Even so-called notice has not been issued, and you have approached the High Court.
That is my entire prayer, lordship, because I'm challenging this order, lordship, without.
Mr. Counsel,
They have still not issued so-called notice,
No, Lordship.
and you have come to the High Court.
Lordship.
They may issue, they may not issue.
But Lordship, my humble submission, if decision is prejudged, before taking a decision, already they have taken given the findings, Lordship. Before issuing a notice to me, they have decided to terminate a contract. That's why, Lordship, kindly see, I am dealing with judgment of Honorable Appellate Court also, Lordship. It cannot be prejudged, it cannot be the notice, it cannot be mere empty formality, Lordship. Lordship, 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 may one thing, Lordship.
Listen to the order.
No, Lordship, my humble submission, one line, Lordship. I am not here to quarrel with Lordship. Lordship, I am here to take some relief. No, Lordship, I am here to get some relief. Only my humble submission, Lordship. Annex 13 series is, I am ready to conclude the work, Lordship.
Please wait.
Lordship,
Hear the order, and if you find that there is something yet to be added, please let us know. All right.
Lordship.
You know our limitations better than what we know.
But Lordship, my humble submission, only Lordship, I want to.
That was an agreement between the petitioner and
Petitioner and Lordship, the opposite parties, the opposite party number, that is superintendent.
road.
Road, Lordship, construction of road. Construction and upgrading of roads, Lordship.
Contract agreement contains provision arbitration in case of any dispute between the parties. It appears from the material on the board that a meeting was held on the key areas of the rural works on 12/1/2024. In relation to the work which was awarded in favor of the petitioner. Being dissatisfied with the petitioner's performance, the committee opined. The committee reached a conclusion that the contract required to be terminated under clause 52.2 bracketed A and bracketed D of the general conditions of contract bracketed GCC of the due procedure as per the standard bidding documents bracketed SBD. So stop. The next, the petitioner has approached this court questioning the opinion formed by the committee in its supposed meeting held on 12/1/2024. So, the counsel for the petitioner has submitted that no notice has so far been issued to him for termination of contract, nor any process has been not any step has been taken in accordance with clause 52.2 bracketed A and C of the GCC so far for termination of contract. For termination of contract. So it appears that somehow the petitioner managed to get a copy of the committee's report dated 12/1/2024 and has filed his representation before
Lordship, Chief Engineer, PM Jai Lordship.
for engineer PMG Pradhan Mantri
Grammar Sadak Yojana. Sadak Yojana. OP3 Lordship.
And counsel appearing on behalf of the petitioner has argued that the opinion formed by the committee is arbitrary on the face of it and the reasons assigned in the said report are extraneous to the terms of agreement.
Yes.
So, he submits that despite representation having been filed by the petitioner dealing with the report dated 12/1/2024, no decision has been taken so far. So, next, in our considered opinion, this clarification is premature. He has also argued that once the committee has taken a decision to terminate the contract, subsequent action of the respondent to terminate the contract by following the principles of natural justice will be a mere formality in the nature of post-decisional hearing. So next, we are of the, after having gone through the pleadings on report and having heard the submissions advanced on behalf of the petitioner, we are of the view that this writ application is premature. So it is not that the committee's decision dated 12/1/2024 can be said to be binding on the petitioner, this in your, that was in your absence.
Lordship.
Finding, which according to the petitioner was recorded behind his back. Process of termination of contract has yet not been terminated, yet not started. So, if the petitioner, if the contract is terminated, the petitioner shall have the opportunity to challenge the same by invoking arbitration clause or any other remedy available to him. The problem. If it also goes without saying that if so-called notice is issued to the petitioner for termination of contract based on the recommendation of the committee, the petitioners have be at liberty to take all such points which have been taken in the presented application. So we have not gone into the merits of the contentions raised on behalf of the petitioner. So it is expected that the opposite parties shall consider the petitioner's reply to the so-called notice issued, if any, in relation to termination of contract. So, next, this writ application is supposed on with the aforesaid object.
Only pre-lordship.
The part with the present order, we deem it apt to notice that the said finding of the committee dated 12/1/2024 pertains to contract 30 contract, including the petition of road construction, including that of the petitioner.
Lordship, only I pray one led observation. So for my representation, they may take it, they may consider.
They will not.
Because I buy
They say that they will not consider.
No, Lordship, is that Lordship, grateful, Lordship.
Item
That will help us,
22.
that's it.
22.
My lord, I am on virtual mode, my lord.
I want a 1 day time to file fresh affidavit, my lord.
All right, first affidavit, additional affidavit. Yes,
Pray, Lords, may post it on Friday.
1 week.
1 day time required to file affidavit, my lord. Regarding posting, my lord, I pray let it come on Friday so that.
We are adjourning it from Tuesday, next Tuesday. In the meanwhile, you do it. This matter on Tuesday. Let additional affidavit be filed in support of sir.
Item 23.
Let's hear in this petition, my lords. I'm a leaseholder. My lords. I am praying, my prayer is very simple. I am not being issued manual Y forms. Even after I have entered into a lease, I have a right to those manual Y forms. No decision with regard to my representation is being taken. I have the right under law to get manual Y forms under 58(2).
What is that?
My lords.
What is that Y form?
It's a transit pass, my lords, that any mining that I do, the minerals, while transporting it to any source, have to carry that to prove the genuineness of the minerals. Because that 58(1), it provides another law that
Wait.
what is a minor minerals concession rules? 2016.
Which
No,
section?
my lord.
Which section? Which?
Rule 58, my lords.
Yeah.
1 and 2, my lords. One is, it says, may I be permitted to place, my
Yes.
lords? No holder of 58 rule 1, subsection 1. Now, my lords, no holder of prospecting license, come mining lease or quarry lease or quarry permit or auction purchaser shall dispatch.
License was granted to you when?
My lords?
When was the license granted?
Yes, my lords. The license was granted on 25/8/2023, and a lease deed was entered into, and I was permitted to go for quarrying operations.
When?
25/8/2023.
Then why are you coming now?
No, my lord. Certain they had previously given me manual Y forms. Now they are saying there's a letter, my lords, at annexure 6, 37.
Ah.
This is my letter requesting them to give me manual Y forms. Now the next page, my lord,
No, why do you want manual Wi-Fi?
yes. Just now, my lords, that's 58(2), my lords. I am not asking for manual Y forms. They can give me EY forms. I have no problem. Now, for getting EY forms, I have to give additional charge to them as per, I have not been communicated anything. What I am being told by this letter. And because of the writ pending with regard to the same lease, they are not issuing me manual Y forms. I've told them this in my letter that this is the problem. Please issue me manual Y forms. I cannot go for EY forms. No decision was taken. I have issued that letter since.
No, I'm finding it difficult to understand.
Millers.
You are interested in manual or electronic?
Milords, manual Y forms I should get as per my lease deed. Now what they have done, they have shifted to EY forms, getting it electronically.
Oh, the EY form was shifted in April 2023.
No. Just in the month of December 2023, after my lease deed. And I have not been communicated anything.
So come to section 58.
2. Lords, it says the transit pass should be printed.
58(1), section 58.
58(1). It says no holder of prospecting license, come mining lease or quarry permit or auction purchaser shall dispatch any minerals from an area without a valid transit pass in Form Y issued by the Deputy Director of Mining Officer having.
Here I'm reading 58(1).
Yes.
Is this an old book? No, your book, it seems.
2019.
Is it 2019 cannot apply?
Milords,
have new book. Read it.
Milords,
Have you read?
let me take instructions on that.
What?
I'll withdraw liberty to file better application. That will be the better thing.
Appearing on behalf of the petitioner seeks permission to withdraw this writ application with a liberty to prefer to make a press application if required.
Yes.
Item 24.
When did you join?
That's just one mistake. I understand.
When did you join bar?
2015.
2015. And you are in 2024 with a book of 2020.
19, Lords, that's a mistake. I'll just check it. That will not affect my litigation, but I'll check it.
24.
I please your lords. If the penalty was imposed 20% of the leftover work without putting in hearing to the petitioner, your lords. And a very cryptic order, your lordship, annexure 1, page 23, your lordships. But no, is page 23, your lordships. Annexure 1, my lord. And this order has very severe civil consequence. Even it amounts to a blacklisting, I cannot participate in tender, my lord. Page 23, your lordships. I am directed the inviting the reference to a letter number 1 December 2023 on the subject as stated above and say the government after careful consideration have been pleased to approve the rescission proposal contract agreement number 103P1 of 2021-21 with levy penalty 20% of the value left over work under clause 2BI of the condition of contract agreement by following the prescribed procedure under the OPW tool. Now, just ECG on 5th February 2024, your lordship kindly have annexure 18, my lord.
Annexure 18.
Your lordships. Page 156, your lordships.
Yes.
Your lordship, this is the on the base, your lordship. This is the regarding address to the bank to purchase my security amount, your lordship. I am permitted to place, your lordship. With reference to subjected, it is intimative that due rescission of the contract MDST Construction Private Limited, Director so-and-so, Government Works Department letter number kindly mailed that 5th February 2024, your lordships. With 20% penalty, the APS amount in shape of bank guarantee of rupees 50,33,000 for rupees 40,24,000 so-and-so hereby forfeited as a penalty measures. Such said amount may be pleased to deposit in the undersigned in the shape of superintending in the R&B division, my lord. My humble submission before lordships, not the penalty in respect of penalty, without putting any show cause notice, you can't impose penalty. That is, my lordship, from the Gurkha security as well as the, my lord, the Radhesham Agrawal case.
Gurkha security is no different.
My lord, they have taken into penalty also part. I have, your lordship, that is blacklisting and penalty. In penalty part also they have taken into, if there is a 20% penalty also, that paragraph 26, 27, that even if there is a power to impose penalty, we can't put hearing to the other side. Yes, that Gurkha security.
Lordship, kindly see page 154, my lord.
No, where any notice was given to
my
him.
lord.
Page 150.
154, my lord.
Yes.
Dated 28/6/2023, my lord. With reference to the above noted subject, it is to say with regret that you have submitted revised work program with commitment to complete of the whole work within the provisional time allowed up to 39/2023. But it is seen that you have executed a work worth of rupees 248,54,231 till date against the agreement value of rupees 906,14,285, which is 27.42% of the total work value, which is extremely poor progress of the work and far behind your work program. The local people as well as the public representative have expressed their deep concern for your poor progress of work and miserable conditions of the road. The fact has also been intimated to you at this office letter number 28/2023. In spite of that, you did not take any effective step to speed up the work so as to complete the same by provisionally allowed period, that is 39/2023.
So notice was given.
No, my lord, I may clarify, my lord. This notice was under 2A. My lord, 2, that is, your lordship, kindly mark the page 154, your lordship. The clause 2A provides for extension of time for, if you suppose I could not do compensation, if I now could not complete the work, they provisionally they recover a penalty and allow time. Your lordship, the clause, your lordship, kindly see 2A, and that is issued by the superintending engineer, my lord.
No.
Your lordship.
The notice is under 2A. The
Your lordship.
notice is a notice for imposition of penalty.
No, my lord, your lordship, kindly have a sub-para, your lordship. That second paragraph, your lordship. The notice under 2A, your lordship. Therefore, you are requested to show cause within 3 days from the date of issue of the letter as to why the compensation. It is not penalty, your lordship. Compensation at the rate of 5% per a day for the balance work calculated rupees so-and-so, 20 will not be levied. Failing with the compensation amount will be recovered from their other work, bill, EMD, security followed rescission proposal. Your lordship, kindly the impugn clause 2A, your lordship, kindly have.
Where?
Clause 2A, your lordships. Page number 52, your lordships. The contract agreement, annexure 5, your lordships. Let's
page,
your lordships. The page 52, your lordships.
Yeah.
Your lordship 2A, your lordships. Mark in second clause 2, thereafter A, your lordships. The compensation.
And where is penalty?
Penalty, your lordship, B, your lordship. Clause B to B. If there is, your lordship, B,
Yes.
Your Lordships. The BI, Your Lordships, which is the rescission of contract. To rescind the contract, which rescission notice in writing to the contractor under the superintending engineer shall be conclusive evident 20% of the value left of work will be realized from the contractor as a penalty, my lords. The 2A and 2B, once you 2A exercise, you can't be 2B, Your Lordships. And furthermore, my lord, on the merit also, my lord, this is the as per the OPWD code, they provides that prerequisites for government approval forest clearance before tender. I have annexed the circular of the PWD code, my lord. Here is the date of the works is 9/1/2022, my lord. And the forest clearance for your lordship kindly have the one document, your lordship, that is annexure 13, page 145, your lordship. Kindly have 145.
And where is the arbitration?
There is no arbitration clause here. Page 145, your lordships. Here is the 10th January is the date of commencement and the completion date 9th October 2022.
This is not covered by GCC.
So this is not where this is the P1 agreement. The standard there is not GCC. And the your lordship annexure 13, page 145, your lordship kindly have to. The requisition of release of
According to you, there is difference between A and B. What is the difference?
A difference, my lord, 2A, your lordships, regarding the extension of time with some penalty, my lord.
Extension of
your lordship, the delay, my lord. Suppose there is a schedule of time period of term.
Clause 2 does not contemplate of any penalty.
2A, your lordships.
Yes, yes.
2A compensation. This is a compensation, not penalty.
B is also compensation.
No, BI, your lordship. BI, sorry. B, there is a B is I, your lordship.
BI is the rescission of contract.
This is part of 2AB, 2A, 2B, 2I, three clauses.
And lordship can see annexure 23, the impugned order, that the rescission has also the penalty. Both, my lord. He is challenging both.
Please. So the contract has been rescinded.
My lord, this is the lordship rescission order annexure 1, my lord. Same day, your lordship, one day. Your lordship. The lordship, the approved was this is also not reasoning mentioned. This regarding forest clearance, no reason also, my lord, assign I have put for this because there is also, my lord, apart from the land acquisition and forest clearance, I have annexed one document where the representative of the one local MLA, he said that this should be a complete other method of work. This should not be also he made some technical changes, my lord. This could have, if the government when approved and he could have noticed, I could have brought to the notice, this is the hindrances, my lord. And you have 2BI directly exercise the penalty, my lord.
My lord, work is marked, he has completed the work up to 27.42%, my lord. And whatever he is raising, my lord, these are the disputed facts, my lord.
No, maybe disputed facts.
My lord.
There, he contains that the procedure has not been followed. So that procedure or aspect we will have to see.
My lord.
He says that no notice was given.
My lord, I'll see.
Let counter affidavit be filed on behalf of the opposite parties.
By 3 weeks time,
3 weeks. Full stop. This case on 3 weeks.
They have in view of that termination, they issued the bank to encash my security amount, my lord. That is the annexure 18, your lord. Lord, there is a week. My lord,
mention after 3 weeks.
My lord, they will encash, my lord. They have directed to your lordship, kindly have annexure 18, my lord. Kindly have annexure 18. Lord, they have directed in view of the government page 156, my lord.
So in view of prima facie, we are of the opinion that while issuing the impugned order, Dated
Milord, 5th February 2024.
5/2/2024. Rescinding the contract and imposing penalty. The opposite parties have not followed the principles of natural justice. So, in such view of the matter, the opposite parties the parties are directed to maintain status quo. Which order is that?
This is next 7th February.
The impugned order shall remain stayed till next date.
Highly blessed. Blessed.
Item number 25.
May I please your lordship? The petition seeks a direction from this honorable court to the opposite party number 2, the collector of the district Balasore, to extend the time period of the tender call notice, my lord. Annexure 1 is the tender call notice where the collector issued and contended that the intending bidders shall submit their tender papers. Sorry. We will not entertain such prayers. Because, my lord, 20 days time is not sufficient to collect the documents for submission. Therefore, I humbly prayed, my lord, 5 days or 7 days time may be allowed to submit my form. To that effect, I have ventilated my grievance before the collector Sundar Balasore. The writ application has been filed for extension of time for submission of bids in relation submission of bids pursuant to tender notice dated
30th January 2024.
13th January 2024.
30, my lord. 30th.
30 January 2024. So stop. The writ jurisdiction under Article 226 of the Constitution of India. We do not see any reason to entertain such prayer. This application is dismissed accordingly. Yes, next.
Item 26.
26, your lordships, breaking the decorum of the court. Though I am not the petitioner, but your lordships, we have filed, we received the copy. We were on caveat, we received the copy on Friday. And your lordships, we found that they have filed manipulated documents before this court. In view of the KD Sharma judgment, if such a practice, they come with unclean hands, the first thing that the court has to see whether such a manipulation has happened or not. In view of that, we filed a miscase today morning. And also my officers are here with the original records to show that how they have manipulated in order to invoke this writ jurisdiction. And in view of that judgment—
Fine, my lord, let the high petitioner will complete this.
In view of that judgment—
You are for whom?
Your lordships, I am for a PSU, OP number 2, 3 and 4, JEDCO, which is involved in the solar power project of the state of Odisha.
And you are for?
I am the petitioner, my lord.
It
is against the state
of India.
Yes, it's a corporation is under the Ministry of Power, the state of Orissa.
Maybe your lordship.
I am the petitioner. Let me complete, then my sister will go on the court.
All right. You are the petitioner. Who is for the state?
My lord, I am a state is a.
And according to you, the petitioners have manufactured documents.
Yes, your lordships. And
It's just vice versa, my lord. That's why I am.
No, it's not. It's not my version. We were on caveat. On Friday, they gave us the copy. And we saw the records that they have filed before your lordships.
No, have you filed your affidavit in this case?
Yes, your lordships.
They filed a copy has been served today.
It's IA. Not I. You have filed a writ petition.
Writ petition, my lord.
Whether any reply has been filed?
No,
they didn't file the reply. They filed a IA only to assist the court submitting some documents which is clarify the position what happened in this case.
No.
Say, let me place this matter.
No,
May I?
just a minute. Let us be clear first.
Yes,
You filed a writ petition.
my lord.
Copy has been served upon.
Because he is a caveator, we file the serve the copy in advance.
Served a copy in advance.
Yes, ma'am.
Whether any reply to the writ petition has been filed or not in
No,
the
they
nature of
instead of filing reply, they file a IA, annexing lot of documents.
IA for what?
Yes, Your Lordship, that's what I wanted to bring.
Dismissal of the writ petition.
No, dismiss, Your Lordships, I just wanted to remind Your Lordships of the very important judgment of KD Sharma, which the court says that if there are fabricated documents on record by the writ petition.
No, madam, fabricated, the documents are fabricated or not.
Yes, Your Lordship.
Will depend on how do you deal with the averments made in the writ petition.
Yes, Your Lordship. I'll clarify on that. Your Lordship, just will bear with me a minute, Your Lordships. They gave us the copy on Friday. We perused all the records with the original records, and all my officers here with the original records. And we found that they have absolutely deleted everything and have filed those documents. So we brought this miscase saying that it should be dismissed on the ground of fraud.
Maybe we don't know what we will be doing.
Lordships.
But first of all, please deal with the averments which have been made in the writ petition by filing a counter affidavit.
We will do that.
In your counter affidavit, you may point out that this averment is incorrect. The document which has been brought on record is manufactured. And then after considering his pleadings and your pleadings, we may take into account the miscellaneous case which you have filed. We will see.
Lordships. But this obviously the time was very short. It's only one working day Saturday. But Your Lordships, as an officer of the court,
exhaustive counter affidavit, if the matter is so
but Your Lordships, I'll just also bring one thing on notice is that the contract has been terminated. And the document on basis of...
See, the principle is very simple.
Lordships.
The moment you are in a position to satisfy the court
Lordships.
On the basis of rival pleadings,
Lordships.
that a particular statement made by the petitioner who has approached this court amounts to misrepresentation.
Yes.
Or is a falsehood.
Lordships.
So even if he has or she has a case,
best of cases,
the court may decline, the court should decline to, so that is simple principle. So you just complete your pleadings and we will see what
And there's one more
for a moment,
please allow him to argue.
She is not allowing that. I cannot enter inside.
Say that only, Your Lordships. The reason of getting this miscase was also in terms of Your Lordship's earlier
Let me complete. I will complete, then you assist the court.
Lordships have already stated that the affidavit has to be in a particular format.
Madam, he has right to argue, address the court.
No, the affidavit thing only is all that I wanted to bring to Your Lordship's notice. Your Lordships have already told us, and very rightly told us, that why our affidavit should be in a particular format. Because unlike like a suit,
You are right.
the pleadings are equal to evidence. Unlike a suit, here documents are not proved either by producing the original or by secondary evidence or by oral evidence. So somebody should take also the responsibility of the documents. That kind of affidavit is missing. That's all I want.
That you should be doing, Mr.
Lord, I'm just clarifying the position of Lord. I'm filing affidavit.
And he'll not say even a single word now. Please make your submissions.
I'm straightway coming to my Lord, this page 428. There is a termination letter issued by the corporation on 3rd February 2024. But such a preoccupied mind they have encased my bank guarantee issuing the letter on 31st of January. Without any notice, without any communication. In other way, we have written the letter to the corporation. You are going to invoke, deputing your officer to Pune to invoke my bank guarantee on 31st January 2024. And what is the reason? You ask me. Or you allow me to go and place my things because I am a company having more than 700 organizations who are doing my Lord. It's a very big company and you are serving in the Rashtriya Dewan to honor many temples, many organizations, Ram Mandir temple, different where they are giving service. So the question of manipulation, all this they are wanting, it does not arise, my Lord. Let's see, you see the conduct of this organization. Let's see, come to the page 422.
No, but can't we wait?
till a counter affidavit is filed.
Yes, counter, but now thing is, my lord, we are in different place. What happened? We have agreement, executed the agreement, November 2017. We have given the bank guarantee. We have started the work. All of a sudden, now they have started operation on 31st. We came from our bankers that they are coming to invoke the bank guarantee on 31st letter. Basing on which letter they are showing that committing fraud, SCCL. This is Southeastern Coal Limited. Till that, we are executing the work. What document you have submitted to this organization, that is letter, that's why in IA, might have the officers not properly instructed my learned sister. She has written that we have given one page. The second page we have written so. The Lordship may see, that is page, Lordship may come to the page 250 for a moment.
No, but why, let us wait. Why should we waste time now, today?
My lord.
Is we can adjourn it for a week. In the meanwhile, you shall be filing your
I will not bother my lord, but Lordship may only protect me, no coercive action.
No.
No further coercive action, because EMD has been taken. Bank guarantee invoked. They are terminate me without any notice, without any success, without any following the natural course of justice.
What protection now you need?
Now I am putting at least because we are doing the many works here. Cuttack municipality we are doing. In Cuttack we are doing 2 projects work. They will affect further. So I am predicting the way vindictive way they are acting against me. It will prejudice again and again to me. So what I am praying, my lord. Lordship may say that no further course of action against me. That will surprise my problem.
1 week boy, what will you do?
Lordships, we have terminated the contract.
List this case
and
on.
it's an arbitration
List
clause.
this case on. 1 week.
Lordships.
Let counter affidavit be filed on behalf of the
OP number 2, 3 and 4.
OP number 2, 3 and 4. In the meanwhile, so the court expects that the parties shall maintain status quo in the meanwhile. No, status quo. In the meanwhile, no coercive action shall be taken against the petitioner in the meanwhile, in pursuance of the order and 3rd February 2000.
Annexure 16, yes. Yes.
Till next date का जो है 1
Obliged man. Much.
Tuesday.
Yes.
Next Tuesday.
Next Tuesday.
Orders item 27.
Item 27, I am appearing on behalf of opposite party, my lord. Similar case matter relates to appointment under rehabilitation scheme.
No, but your
similar order already, this honorable court already passed, my lord.
Your appeal is time barred.
No, my lord.
My lord, this
I am for the appellant. He is for the respondent.
My lord, similar order is to be passed.
You are for whom?
Opposite party, my lord.
Let him argue.
Yes, but similar batch case already decided.
I am submitting
by this honorable court.
There is a delay of 227 days in filing this appeal. What has happened in the facts of the case is that it's a case where direction has been given to consider his case in accordance with the ratio decided in the case of Malayananda Sethi versus State of Odisha. In that case, what the principle has been decided, and in that Malayananda Sethi case, that in 2020 rehabilitation assistance scheme was said a new policy has came into force from 17 to 2020. That in that rule 69 says all the pending cases shall be covered under new rule, and those
Going
cases
to the merit of the case, then the delay has not
yes,
been.
that they have only 227
Have you
days.
filed any objection to
He
the
had to
delay?
file an objection on my deal.
That principle has already been decided by this honorable court in previous occasion, but through a judgment, my lord. The lordship may see. All these things have already been discussed there, my lord.
Sir, your appeal is incompetent.
Yes.
And it cannot be heard. All right. Because it is time barred and the delay has not been controlled. Yes. So once the delay is condoned, your appeal would become competent and then only we can hear you on bail. Not you, his appeal.
Yes,
Not your appeal.
So there is a delay of 227 days delay in filing this appeal. So your lordship may issue notice on the appeal because he has appeared. I'll serve him a copy on my petition. If
No,
he
but
has,
why? How do you explain this?
that in fact, my explanation is only official communication. There is no other explanation.
All right, that is one aspect. The other aspect is, is this your stand that this case is distinguishable from the other cases?
Yes, ma'am. Not distinct. I am submitting that. What has happened in those cases, your lordship has held that they are covered under old rule. So we have challenged that judgment and that is pending also before the Honorable Apex Court.
That we can challenge again.
Yes, ma'am.
Delay condoned to it, so
This order may be observed, my lord.
Giving
yes,
that.
do you have any objection to condonation of delay?
Yes, I have no objection.
Then file then.
Let it take disposed of by of this.
He should not have objected.
No.
He should not have objected.
Sorry, my lord. Sorry. I couldn't follow.
There is 227 days delay in referring this intra-court appeal. So stop. IA number?
That is 4924.
IA number 4924.
Or 23.
And counsel for the contesting opposite party does not have any objection to the prayer for condonation of delay. Stop. The delay stands condoned. Stop.
I am giving that judgment, my lord.
Please give.
Sorry, my lord. କୋଉଟା ଦେଇଛନ୍ତି? କୋଉ ଜଜମେଣ୍ଟଟା ଦେଇଛନ୍ତି?
This is State of Odisha versus Santosh Kumar Parikh.
No, my lord, that will not help. Your lordship may see this judgment. Why I am saying that is a sorry, my lord, one copy there.
It's all right, we will share.
A batch of writ appeals were disposed of by my lords.
Main judgment, my lord, that was passed.
This order.
Main judgment is there.
Challenge is annexure 2.
Ma'am.
That is not readable.
That only direction where the entire problem lies, my lord, the direction was to consider his
It
case.
is not readable, Mr. Totally. Why do not a neat type copy of it?
Yes, I.
According to you, the decision which has been cited by him, the order, your case is not covered in by that order.
Santosh Parikh case, that has been dismissed on the ground of limitation. That I have given that main copy, that Bindu Sagar judgment.
Main copy I have submitted.
No, ସିଏ ଦଉଛି ବିନ୍ଦୁ ସାଗରକୁ ରିଲାଏ କରି ଯୋଉଟା ହେଇଛି. I have given that Bindu Sagar judgment.
The Lenin single judge has held that it is to consider the case of the petitioner.
In accordance with Molananda Sethi case. Yes, my lord.
Do you mean to say that this
Molananda Sethi case, my lord,
is different?
Yes, no, not different. In that case, the Honorable Supreme Court, I am giving that copy, my lord, that the lordship is.
No stay was allowed in Supreme Court, my lord.
Contention was raised that it is covered by the judgment of the Honorable Supreme Court in the case of that
Molananda Sethi case. In that Molananda Sethi case, Honorable Supreme Court has said that the principle is kept open, my lord. The lordship can get it from paragraph 14.
Just
So whether his case is covered by this Hindu Sagar Samanatara, Samantara. That
And on the city's case was also
taken into account in that Bindu Sagar case. What is the problem in this case? Only one different. All these cases are disputed upon the very first day. It's a case of rehabilitation. He applied in 2012, 2013. He approved my lots in 2023, and there is a limitation of 10 years. After 10 years, he has approved my lots, and the Honorable Court has directed to consider his case in accordance with that Molananda City case. Even if that principle is that has been decided in that Molananda City case, that old rule will govern those cases who are died prior to 17 to 2020. Here, the facts somehow different that he has approved my lots after 10 years. This is a case of
when the order was passed, you were present.
The very
you
fast,
did not dispute that position.
Our ground is very fast.
No, it is not very fast day. It is
Yes.
order number 3.
Yes.
And the C number, paragraph number 4. Please come to the
Yes,
order. Please come to the order dated annexure 2,
Yes,
order
ma'am.
page number 50.
I have seen that. I will not.
That is order number 3. And it is mentioned in paragraph number 2 that hired the Land and Council for the
I have seen that.
parties.
But
Again, in paragraph number 4, Land and State Council does not dispute the
I will
position.
not dispute that because Your Lordship, the only position that our submissions are recorded. Your Lordship may cover that matter in that accordance with Bindu Sagar. View of what has been observed by single judge in the impugned order dated, what is the date?
24/11/2020.
24/11/2022.
in WPC number 25294 of 2022, we see no reason to interfere as the order was passed in the presence of London State Council after having taken note of the submissions advanced on behalf of the estate. Full stop. London Council representing the parties do not dispute that the petitioners, that the case of the sole opposite party is covered by, opposite party bracketed writ petitioner is covered by division bench decision of this court in case of ordinance bench decision of this court in case of State of Orissa and others versus Bindu Sagar Samantarai. Rendered on 25/9/2023 in WA number 810 of 2021 and another analogous cases, as well as Malayanand City versus State of Odisha and others. Stop. The said decision in case of reported in 2022 SCC online SC 684. Stop. In such view of the matter, this appeal stands disposed of in terms of this court's decision in case of Bindu Sagar Samantarai bracketed supra. All interlocutory applications, if any, stand disposed of.
Item 28.
There is a delay.
Yes.
Delay of 110 days.
10 days. Yes.
My lord, in this case, I have been instructed to appear in this case, my lord.
So delay we are condoning will come for admission.
My lord, prior to that, the lordship may kindly see, the lordship, the division bench has already reviewed the matter, and thereafter they have approached the Honorable Supreme Court, and the Supreme Court has also dismissed the.
It has been asked to you that whether you have any grievance so far as the delay aspect is concerned.
My lord.
Whether you have objection so far as condonation of delay is concerned, then we will go to hear the matter on merit. No objection.
Delay condone करने दीजिए.
Your lordship condone the delay. I have no objection.
Delay condone. Yes. What else? Can it be disposed of?
My lord, it is a reply.
It's reply.
My lord.
But this is your appeal. How will you reply?
My lord, may I take my lords to directly to the order page 24, please?
So it is not covered by any decision.
No, my lord.
No, admission के लिए बोलता हूँ.
Admission heading में ले.
I don't know. This is matter for admission. Yes.
Item 29.
Which time may be permitted, my lord, I will file additional affidavit.
No, but what for it has come?
For admission, man.
No. It is also for orders, no?
For admission, man.
Admission.
Alright. Oh. All right, as requested on behalf of the petitioner, does this matter on? When do you want?
After 2 weeks.
Weeks.
Oblige. Item 30.
My lord, item 30, I pray for 1 week time, my lord.
1 week.
Item 31.
In this case, there are two set of writ petition. One is prepared by the Union of India, another is prepared by the private opposite party. It was challenged against the order of the Learned Sentence Tribunal, wherein the Learned Sentence Tribunal allow the petitioner to whatever money has been paid to him for a particular period is about 1 lakh some odd, which has been deducted by the department after his retirement. It is a case that this petitioner is said that even though it was deducted wrongly, it was paid, but basing on the provision of law, you can't deduct for my.
This is what the Supreme Court says, that you cannot deduct after retirement.
But rules is some other my lord.
So this is what the Supreme Court has let down.
Rule 39 of the FSR, this is leave and case leave rules, part 3 of FRSR. It is said that this department has a power to deduct this, even though it is a
that power is there
on leave or half pay leave.
When did he retire?
He retired on 2017.
2017.
My lord. Last order, my lord, directed what is the admitted due of 3 lakh some odd, you pay him. On the draft we have come and he handed over to my plant friend, he has accepted this. The dispute is 1 lakh some odd. No. Which was is it paid as a more than his entertainment. So this question will be decided by.
So 1 lakh more was paid to him.
1 lakh 74 like this 74. 1 lakh 66 some odd.
So when had he taken more?
It was taken during the period. It is from 2010 to 2014, my lord. Audit was found, it is on 14/8/2015. Audit objection was called for, thereafter came to know that this amount has been paid more than is entitled. Against which you will be.
And he retired on?
31/7/2017.
Have you come with the Supreme Court's decision on this point?
Yes, ma'am.
Do you have the Supreme Court's decision?
I have already filed my notes of argument and citation also.
Top of the record. Yes, it is.
Your Lordship may kindly see the impulsed order. My learned friend is confused. Your Lordship may kindly see the impulsed order at page 66, paragraph 8 and 9. There is no question of excess payment. The question of interest on the yarn leave.
Interest on?
Yarn leave. Because
Yarn leave?
Yes, my lord.
That's on unleave. Unleave encashment.
Encashment.
Yes.
My lord, my yarn leave is
you cannot earn interest on leave.
On leave. Here, my lord, my leave was for 293 days. Yarn leave, 7 days for half pay leave. They have calculated 5,66,000. 5,66,000. They have not paid it. I prefer the original application where the London Trial Court directed to disperse 3,88,000. What they have filled for admitted 548 within 2 months. along with interest from 1/8/2017 till actual payment of disbursement at the rate of 9%. So for admitted dues, they have paid in pendency of this rate application by the order of this honorable court. So for yearly, what my friend says that is the interest. There is no balance amount. Rather, the London trial court says that you may take act upon the balance amount. Your lords may kindly see that subject to the interest paid will be recovered from the officials who are responsible for wrongly withholding the leave encashment payable to the applicant in full in violation of the provisions of the rules. The respondents are further directed to pass specific order regarding the balance amount of leave encashment benefit to the applicant in accordance with the provision of law and communicate a copy of such order to the applicant within 3 months from the date of receipt of a copy of this order. And if applicant is aggrieved by such order, he will have liberty to challenge in accordance with law. Then the so far interest component is concerned, he has come forward before this honorable court. And so regarding that interest component, I have filed 2 judgments before my lord in my notes of arguments. That is Vijay L. Mehrotra versus State of UP report. That is in my notes of argument, my lords, before. 2001, volume 9, SEC page 687. Where the Honorable Court also, Honorable Supreme Court said simple interest awarded 18% from the date of retirement till actual payment. And another judgment, SR Bhanrale versus Union of India.
Yes.
That is 1996, volume 10, SEC page 172. Let my learned friend submit. Regarding the rules, my lord, that is-
Additional affidavit in WPC number 9987/2021. 9987.
Filed additional affidavit.
Yes, we have filed. I'm sorry, my lord, we have paginated, that's why I closed the plan. In
Yes.
that affidavit, that is dated 31/2023. It is the latest affidavit filed by the department.
Yes.
Paragraph 4, I'm just pressing. Lordship got it. May I press, ma'am?
Page?
This internal page 2 of this affidavit and paragraph 4. Para 4.
Annexure?
That is not annexure, my lord. Additionally, para 4. That in compliance of the order of the Honorable Court dated 5/1/2023. That
Just
Court dated 5/1/2023. The petitioners have put forth that the opposite party number party Sri MD Ahmad Beg, ex-SA, HRO Barampur, RMS, was retired from government service on superannuation on 31/7/2017. At the time of retirement, 293 days earned leave and 132 days half leave, pay leave are at credit. Accordingly, the 5,56,234 was calculated to the drawn towards case equivalent of the leave from 293 days of EL and 7 days HPL. That an amount of 1,67,000 was to be recovered from the said amount as the same has been paid excess to the opposite party. What I am clarifying, my lord. Therefore, also I am coming to para 5. That due to change of that MSCP 3, an amount of 1,67,687 was to be recovered from the opposite party. As per report of internal audit postal wing. Accordingly, the check of rupees 3 lakh was drawn in 5/9/2018 in favor of the opposite party number 5, opposite party. The opposite party refused to receive the same as per his letter dated 29/10/2018. Both the documents are under Annexure 5 and Annexure respectively. We have prepared the draft 3 lakh sum out on 2018. He refused to accept this same. For which, what interest they have claimed before us, it will not be acceptable, we cannot pay, my lord. After that, when the court directed the same amount, the 3 lakhs amount has been drawn in favor of the petitioner, valid draft, and it will be handed over to them. The only dispute is 1,67,8686, which is not legally entitled to. That's why it could not be paid. This is the Will you write the this Swami's
May kindly see
pension
that,
compliance rule, that is F
that rules 39.
3. Yes, sir.
Sir, let me say.
How come?
39.3. FRSR rule, leave rule, that is 39.3.
What do you want to say based on
Millards.
39?
The language is that there must be, they can withdraw the earn leave subject to pendency of the departmental proceeding or criminal proceeding. Here, my lord, they are silent as on date also. Is there any proceeding is pending or not? The language says the authority competent to grant leave withhold a whole or part of the cash equivalent of earn leave in case of government servant who retired from service on attaining the age of superannuation.
All right, we will decide.
And retirement while suspension or while disciplinary or criminal proceeding are pending. Here there is no answer to that. Is there any departmental proceeding or criminal proceeding is pending?
Okay.
So far, my lord, what my learned friend has said, 1,66,000. That has not been pleaded before the learned tribunal. Now it has been developed that the overdues of 1,66,000 is paid. Nor the learned tribunal has answered them, as because there was no pleading to that extent. Rather, the learned trial court says that only a letter has been issued, no check has been given. There is no question of refusal at all. The learned tribunal gave the findings that there is a letter only issued to take the amount without giving the amount. That is at page 66, paragraph 8 of the order itself. And the learned tribunal held when that amount has not been paid at all, only a letter has been given. When I am entitled to get the admitted dues, then they are liable to pay.
All right.
Apart from that, the learned tribunal give the scope to them to give a chance or to give a show cause to me for recovery the amount. They have not done so.
All right.
Now a case has been made out that one MSCP was pending for which I want to recover. And there is no letter, no correspondence, no recovery,
All right.
no proceeding has been made to that extent.
We will see. Hard. Also, or reserved.
Yes. Both the case can be.
No, both the cases. That's it. Sub item is different to the first item. Sub item is different. So far another writ application is concerned, it is a different case altogether. It has no connection with this.
The order of the tribunal is same. Or different?
No. Different.
Two different orders are there.
Yes. Two different proceedings, two different way.
All right.
In first item, your lordship may.
WPC 9987 of 2021.
My
There
lord,
is no way connected to the other WPC.
6429 by 20.
It's total different.
Total different.
So, Mr. Pari?
Yes,
this
yes.
Second one?
It is out of the same issue, my lord.
No, my lord. There is no issue at all.
What is the second?
Again.
What is the prayer in this second one?
Second one, my lord, I claim MSCP, third MSCP, which has been offsetted, for which I filed the original application. The learned tribunal has answered that. When I not challenge the original order, BCP is the order, and my prayer governed under a judgment of this honorable court. That's why I am not entitled. That is altogether different to this case. Your lords may segregate that matter.
You may then split up the same and because this annexure 16, 17, they have
First go. Yeah. And second business matter on 1 week.
Item 32.
I'm appearing for the opposite party number 2 here. It arises of
Appearing for the tendering authority, OP number 1, that is Orissa Bridge Construction Corporation, my lords. Work has been awarded to L&T, my friend's company, my lords. And they have executed roughly 30% of the work. This is the SCB Medical College, and is going to become one of the biggest medical centers in India, my lords. 30% of the work has been executed by them. So the petitioner,
I would draw my lord's attention is that this court had earlier passed an interim order saying that subject to the interim orders, final orders of this court, the work will be awarded. That was carried to the Honorable Supreme Court. The Supreme Court order, if I may give that, that's also on record. Supreme Court order takes note that the contract has already been awarded and has made a request for the High Court to dispose of the matter. Since the petitioner earlier also has not turned up on one occasion, since he's not turning up, my lord may take note of that fact. But it was my duty to bring it to this the notice of this court that the order of the Supreme Court says that the High Court has to dispose it of within a stipulation. I'm just giving a copy of that.
You are representing the petitioner.
No, I'm the successful bidder. Larsen and Toubro, OP number 2.
Petitioner is not turning up. On the last 2 occasions, he has not.
There is no representation on behalf of the petitioner. For there has been no representation on behalf of the petitioner for last 3 consecutive days.
Not 3 consecutive. One date it didn't appear, then next date they appeared. And today is the second default.
Second, I mean, it appears on some date and then.
There is no representation on behalf of the petitioner. And senior counsel for
Orissa Bridge, the tendering authority.
Was it party number?
1.
Was it party number 1?
And I'm for opposite party number 2. Larsen and Toubro.
Present. So stop. This application is dismissed for default.
You're all great.
Item 33.
Well, its interim orders may stand vacated.
Complete the work as quick as possible. Everybody is waiting for that work.
Yes, well, we are doing our best.
In fact, we have got pictures of this. It's come up very wonderfully. It's come up. If my lord wants, we can show them. The scenery there is looking very good. In fact, we never knew that it will not turn up.
These are the pictures of the.
My lord may see after that page 4 onwards, the progress photos we have given.
This is a project roughly 2,800 crores. Obliged.
You're all great.
Item number 33.
May I please, ma'am? My last occasion, your lordship have been pleased to direct me to explain as to the impugned order has any statutory force. Your lordship, I pray that this kindly have a glance at Annexure 7 at page 43. 43 in that order. This has been this order has been gazetted. It has assumed issued in the gazette notification on 31st December 2014, and it has been written in exercise of the powers.
Allocation. Yes, in exercise of power.
In exercise of the powers conferred by subsection 4
Yes.
In exercise of the powers conferred by subsection 4 of section 7C of the Odisha Education Act 1969, the state government.
Council, please appreciate
Well,
that whether that order can be treated to be a rule in the nature of rule or a statutory provision.
Statutory provision is
It is not statutory provision.
My lord, this is the statutory provision. Let's glance at Odisha Education Act 7C.
Please read 7C.
Yes, yes. Seven C. At page 137. At page 137.
Read.
7C, granting aid, the state government shall, within the limits of its economic capacity, set up at a sum of money annually for being given as granting aid to private educational institution in the state. 2. No order according permission or approval or recognition under this act, whether prior to or after the commencement of the Odisha Education Act, Amendment Act 1994, shall entitle any private educational institution to receive granting aid. Section 4 is important. Notwithstanding anything contained in any law, rule, executive order, or any judgment, decree, or order any court, no granting aid shall be paid, and no payment towards salary cost or any other expenses shall be made to
Mr. Counsel,
sir.
Please read slowly. No granting aid shall be paid.
My lord.
Then
Towards cost or any other expense shall be made to any private educational institution or for any post or to any person employed in any such institution after the commencement of the Odisha Education Amendment Act 1994, except in accordance with an order or a rule made under this act. My humble submission is that this is the enabling provision by which, in exercise of this provision, this block grant order 2014 has been
all right. Let us
issued.
see.
My
Page.
Page 43, Annex 7.
Page 43.
Annex 7. May I read?
Wait.
Item number 400. Sir, which page?
43.
33.
My lord. This is the Gazette notification about this block grant order 2014. And notification was dated on 31st December 2014. And the order is that in
It's 43. 43, you say.
my
Yes.
in exercise of the powers conferred by subsection 4 of section 4C of the Odisha Education Act 1969, the state government do hereby make the following order to regulate payment of granting aid in shape of block grant to private educational institutions or for any post or to any person employed in such institution, being a non-government college, junior college, or higher secondary school, as specified here under namely. My lord, such are these are the provisions.
Yes.
So my humble submission is that under section in exercise of the powers conferred on section 7C subclause 4, this block
Yes,
grant.
we'll see that aspect. Come on the merits.
My lord. Merit is my lord. The petitioner, who is a lady attendant, has been working for 25 years in a college.
When you are challenging statutory provision, then you are not required to refer to fact.
My lord, kindly have the space 63. I have challenged this last para of this impugned order. Your Lord's kind of 63. 63. This is the impugned order I have done. Para 2 or para 4. Last paragraph. Paragraph is page 63. Yes. If any teaching or non-teaching post is required in an aided institution beyond what is admissible, as mentioned above, the salary or non-salary costs of such posts shall be borne by the governing body, and the state government shall bear no liability for the same. This is the impugned, or I challenge this provision. This provision that now once a person or an employee is unable to get granted under a particular granted order, then he or she shall continue to be an employee, a management employee till her or his retirement. So this is provision is discriminatory or arbitrary. And in the instant case, this lady attendant who happens to be is entitled was expected to be entitled to get granted with the approval of order of 2009, but because she could not join by 1/6/1998 and she joined on 7/12/1998, so she was not considered for granted in the 2009. But as per this provision of this granted order, that those employees who have.
So one thing is clear, that you are entitled to grant in aid if this provision is held to be ultra virus. And if it is held to be intra-virus, then you are not entitled to grant.
I have not entitled.
It's clear?
And another fact is that when the petitioner was appointed, at that time the rule 77 yardstick was prevailing.
No, that is different. Now you should be clear in your stand. If your entire case is based on this, if you are questioning the virus of a statutory provision, then we will be deciding the virus. And if the virus is decided in your favor, you take the benefit. If decided against you, you lose it. But are we required to go into facts further?
This is the constitutional
position. It has come before the revision bench only because you are challenging the virus. So we will decide the virus aspect. Nothing more is to be required. All right. Third, and counsel for the petitioner. Date 2 weeks for judgment. Yes.
34.
My lord, item 34, may I pray, my lord, may kindly be taken up on Wednesday. The Advocate General will address my lord something.
As requested on behalf of the.
It is from Monday, my lord. I am for the respondent. Monday.
List this matter on.
Then, my lord, next week, Wednesday.
Next week, Wednesday.
Obliged.
35.
My lord, item 35 and 36, I pray for an adjournment. 35 and 36.
One thing I'll just, my lord may take time, but a batch of cases along with this case that was listed before this division bench of this Honorable Court on 15th May 2023. And thereafter, this particular matter where I am appearing, that writ appeal number 557 of 2002, somehow segregated, but other matters were listed before the division bench and that has been already dismissed. And the matter which has been dismissed, the judgment which was passed by the single judge, that has been relied upon by in my case, by the single judge. This say that having been dismissed, this is also covered by that. I can
You'll see.
let him look to that.
You'll see.
A batch of cases.
As requested on behalf of the estate, it is this matter on. When do you want?
1 week after.
1 week.
Quite slow, 1 week after.
1 week.
My Lord, when request that next week.
Next week, my lord, since 2006, and so many candidates has gone by without job. That is why I'm playing with your lordship next week.
Anyway, Lord, say, Ajit,
Yes, ma'am.
That will do.
Fine, right, fine.
Just point out.
Fine.
If the matter, your matter is not taken up, just point out, we will take.
My lord, deep privilege, ma'am, deep privilege.
Another matter, 862 of 2022 may be listed along with the same matter.
35, 36.
Item 37.
And I'm for the appellant. But I'm for the appellant. Lordship, before I take your lordship to the impugned order, may I pray your lordship to have that the record of right of the translated copy of the record of right I have already placed on record. Page 51 to 53, I have translated that your lordship kindly have. That's for the. Or just in case it is not there, I'm giving one copy of the translated copy of the record of right. Very shortly, your lordship, I'm putting the facts. Lordship, kindly have that page 51, that's the translated copy which I have given.
Yes.
There are 7 persons who jointly recorded the Royat column. That's Golabatan, Pradhan, so and so. There are 2 of them before your lordship. Now, the total extent of land under this Khatian is 27 acres. The last page, your lordship. Out of this, my lord, by the 2 of the petitioners jointly want to sell an area of 1 acre in favor of a company. Admittedly, these lands have not been partitioned by metes and bounds or by decree of the court, any, and it continued to be joint holding land. This they wanted to sell in favor of a proposed vendor, and this has been refused by the sub-register on the ground that the sale contravenes section 44 of the Transfer of Property Act. Now, I filed in appeal, and the Honorable Single Judge, directly I'm taking to the finding part, lordship kindly turn to page 30 of the brief. Page 30, lordship kindly have internal page 9 of the impugned judgment.
Yes.
In the instant case, although the petitioner have right to alienate their share in the joint family property, but they have
page
30, in internal page 9. In the instant case, although the petitioner have right to alienate their share in joint family property, but they have no right to alienate any specific parcel of land as provided in section 44 of the Transfer of Property Act. Thus, the registering officer before registration has duty to examine as to whether the petitioner have right to transfer specific parcel of land which is admittedly absent in the instant case, and there is no material to establish the said particular parcel of land is allotted to their share. The registering officer cannot be a mute spectator to the infraction of law. In that view of the matter, the registering officer has competency to delve into the issue as provided in section 44 of the Transfer of Property Act. Yes. I'm drawing lots of attention to section 44 of the DP.
Yes. TPA.
Mr. Kindly.
So what was your grievance before the learned single judge?
My lord, my grievance is that I am a shareholder in respect of this joint holding, and we want to alienate out of our share a particular parcel of land. Now, admittedly, there is no partition either by mixed and bounds or by decree of the court. So, as per section 44, even if we sell a particular parcel of land, that will nonetheless, the vendee's right over that will be as good a joint possession. And whenever there will be a partition, he cannot claim this specific parcel. So, therefore, the sale deed does not contravene 44. And it should have been registered.
Who declined?
The register declined. Then I followed it up in appeal and unsuccessfully. And then I came back before your lordship in the single.
Have whether the counter affidavit been filed?
No, my lord.
File a counter affidavit.
My lord, it's a question of law and simply, and I have given.
But still, they will have to be given an opportunity.
My lord, already the lordship can see from the last order, there are several occasions.
Time was given.
Yes, my lord, at least 4 to 5 times is given. And they are in need of money, and that is why they have.
How can you decline to register a document?
My lord, let me be allowed to place the facts. There is a joint family property. There are 6 co-sharers. There is no partition amongst those co-sharers. It is a joint property. Every co-sharer has right over every inch of.
Now we just conceive of a situation. He wants to get a sale deed registered in respect of a land which does not belong to him.
Yes, it's the worst case.
And the vendee is inclined to get that deed executed.
In that
Can
case,
the registering authority
in that
decline?
case, the Honorable Single Judge has dealt with this fact that this sub-register cannot be a mute spectator, at least a transparent.
Mute spectator, this is what the Supreme Court says.
It's an administrative job, my lord. That's judgment.
That has to be done. That cannot be refused.
My lord, then there will be a flood of all.
Yes, that can happen. This is what the Supreme Court says, and we are bound to follow.
Then I will take instruction. I will
Take
file a
instructions.
counter. I will file a counter.
Take instructions. What you cannot decide the title or what will happen or what can happen or what shall not happen. Your job is to register a document.
And it's an administrative job as has been laid down by the Honorable Apex Court. You can, and by way of this impugned order, the Honorable Single Judge has conferred an adjudicatory power. And
but there are some decisions where
there are no.
Yes, I will cite in my counter affidavit. I will cite.
Yes, my lord. I've given a bunch of decisions.
I will cite my.
That's already on record. And there is the 3 judge bench, full bench decision of the Punjab and Haryana High Court, which has been quoted in approval at least by 2 Supreme Court judgments in 2016 and before that in 2009. On the same point, my lord, a specific parcel of land can be alienated. There is no bar. The vendee will only step into the shoe of the vendor, and in the ultimate partition, he may or may not get that property.
And partition even otherwise, if the vendee is ready to pay something,
my lord,
to the vendor,
and we have written it in the
knowing well that he does not have any right, and the registering authority cannot decline to register.
And in our sale deed, we have stated that.
And because
we have disclosed that.
Other co-sharers have not given consent to this transaction.
They are not he does not have any jurisdiction to enter into such aspects. The registering authority.
Yes, I will just file a counter on this. 4 weeks
by
time.
way of last indulgence.
But 4 weeks I oppose.
2 weeks time is allowed for the estate to file counter affidavit. The court will take a serious note of the matter if no such counter affidavit is
We will
filed
file it. We will file it.
by the next date. 2 weeks.
Obliged.
38.
Item 38, my lord, I pray for an adjournment and meanwhile to find the state to file the counter, my lord. The notice has already been issued now.
You are seeking adjournment. You want state to file counter affidavit.
Meanwhile, the matter has been before already.
Seek adjournment, we will see. As requested, how much time?
2 weeks, my lord.
As requested on behalf of the petitioner, this matter on 2 weeks. Of the estate shall be at liberty to file its counter affidavit in the meanwhile.
Item 39.
I beg.
Item 39.
May I say?
You are directed to get an instruction. You are directed to take an instruction for that footbridge has been constructed in the station of Chhatrapur in Barampur, or not? One footbridge which will going to be constructed by railway in the station Chhatrapur. We have taken the instruction that the government of India has took up the project on the Amrit Bharat station scheme. There is a scheme floated by the government of India named Amrit Bharat, based on which the scheme has been adopted for this station, and it will be completed the work within a very short period. We have floated the tender, but in the meantime some problem is there. Again, the tender will floated and it will complete. In that context, we are filing a affidavit file. But what is your problem?
I beg to submit my that they are saying such version 3 to 4 times before the Honorable Court, but they are not doing the work. Foot over bridge, my lord. The public are suffering, so many public damage by accident. And
that's why I'm getting affidavit from my officers. They will file the affidavit.
Latest order may kindly seen that my lord's
24/1/2024.
Let me say that my lord's observation last order that when they will start and when they will complete it.
No, we have written.
They should say so.
No, we have written that it will be tender was reopened on 26/2/2024. They must have reopened, my lord. The 26/2/2024 is the date. The fresh tender will be reopened on dated 16/2/2024. The work will be commenced after issuance of the letter of acceptance LOA.
Again,
we have written it.
Again, more than 2 years I filed this. And every time you are saying so. Public suffering like anything, my lord. Since, my lord, the Chhatrapur main station was constructed in 1899.
You are petitioner in person.
My lord.
Are you petitioner in person?
No.
Petitioner is a practicing lawyer.
They are, my lord, that petitioner was in Chhatrapur stations nearby, my lord, and they are public, all are suffering. They are Malgadi are standing there, they are going to running on the train line. So many people should damage, so many cow, buffalo, and all damage. She
is a practicing lawyer and has approached this court by filing present rate application in the present of public interest litigation, directing the opposite parties number 1 to 4 to take steps to complete the foot over bridge from north to south from platform number 1 to newly constructed
1 to 3 and then
1 to 3
and then
newly constructed platform number 4 and 5 to facilitate convenience of the general passengers at railway station. Which railway station?
Main Chhatrapur main railway station.
At Chhatrapur main railway station. Stop. A counter affidavit has been filed on behalf of the opposite parties today, which has been taken on record. It has been stated inter alia in the counter affidavit that recently a fresh tender has been issued on 25/1/2024 for construction of the overbridges which are half constructed. The tender was supposed to be reopened on 16/2/2024, as stated in the counter affidavit. Stop. It has further been stated that the work will begin soon after issuance of the letter of acceptance, possibly in the month of May, and the work shall be completed within 6 months. Stop. Next. In view of the statements which have been made in the today's counter affidavit filed on behalf of the Union of India, this application is disposed of with a direction to the opposite parties to ensure that the work of construction of railway overbridge, public bridges is completed within 6 months from today. Full stop. We, keeping in mind the public interest involved in the matter, we give liberty to the petitioner to approach this court if the work is not completed within the period as specified in the present order.
You have received the copy of this additional affidavit.
Yes, my lord.
Obligement.
Item 40.
Item 40, your lordship. I'll file supplementary affidavit in this matter.
Additional affidavit.
41.
My lord, the virus of the same order as has been made out in 33, the virus has been challenged, but the other players are different. So I pray that the two matters may be tagged together.
It will not be tagged. This matter after 2 weeks. Let that be decided first.
My lord.
Let that case be decided first, then we will see.
My lord.
42.
In this case, my lord, I am filing the counter affidavit filed by the state in WPC 27829 of 2021. I am adopting that counter. In both the cases, I am filing.
Which case?
My
Which item?
Item 42, my lord.
42, my lord.
42.
My
No, you have filed counter affidavit in which item?
in WPC 27829, my lord. In similar matter, my lord.
Similar.
2782.
27829 of 2021.
829 or 858 na? 829.
This is some copy, another case. This case is not in the list.
Which one?
The counter which they have adopting, that has not been listed.
That has not been listed.
Not in which matters. Similar writ petition, we have filed counter affidavit. I am adopting this here counter in the present case.
So all the cases should be heard together.
My
Yes.
How many such cases are there?
5 to 6 cases I have already handed a list of.
Plus this matter along 4 cases, brother. On 2 weeks. The top learned counsel
learned AGA appearing on behalf of the estate has informed this court that a counter affidavit has been filed in WPC number
27829 of 2021.
which shall be accelerated. Most of the adjournments made in the said counter affidavit shall be utilized for other cases also.
My lord,
On behalf of the estate. Full stop. Yes.
But if required, we will file rejoinder affidavit. We'll go through the, today just now, they have solved. So if necessary, we'll file rejoinder.
Petitioners seek adjournment to file a rejoinder affidavit. Full stop. They shall be at liberty to do so. This matters on 3 weeks.
my lord, may submit, my lord, in my case, the second sub-item, 27858, they have already filed a counter. And that counter should go in that case. That cannot,
there.
they have filed a counter, I have filed a rejoinder. That pleading is complete. So this counter may not, I do not
No,
know. I
my
have
lord,
not
that
seen
counter
it.
affidavit was even though filed the all the parties by the superintendent of excise, my lord. And that's why because the state has filed this counter affidavit because state has imposed the COVID fee.
The state has filed that other counter.
No.
1 to
That
4.
was filed by the superintendent of excise.
4.
On
You
behalf
cannot
of
say
state, but that
state
was
has
filed by
not
the
filed.
superintendent of excise.
I'm sorry, my lord, these counter have been filed on behalf of OP number 1 to 4. I mean, all the opposite parties, they have
It
filed.
happens sometimes. You just see the counter affidavit, and if according to you, some material is there in this affidavit, which is required to be dealt with, you do it.
My lord.
We will see at the time of hearing.
My lord.
Yes.
Appellate.
Item 43.
Item 43, counter affidavit not filed. Filed by my lord in last order. In last.
Counter affidavit was directed.
Yes, my lord, I have received the instruction also. I will file in safe of affidavit.
How much time?
2 weeks time.
As requested on behalf of the estate, 2 weeks further time is allowed to file counter affidavit.
Item 44.
The respondent number 1, 6 months time for filing the counter.
Counter in appeal.
Here to file any objection to my limitation, your lordship has issued notice by the order dated 18 for 2023 on the ground of limitation.
No, we will not allow you to file any counter affidavit in appeal.
Delay, my lord. 520.
No, not 500, only 202 because that limitation it starts from 1/6/2022 because of that COVID period.
File objection, my lord.
So file objection. File objection. 1 week. 1 week time is allowed to the opposite party number 1.
Opposite.
File objection to limitation petition filed on behalf of the appellate. Filed by the appellate.
Obliged.
45.
Already in item 45, I have served, I have filed an additional affidavit, but I couldn't serve copy on my friend. I'll be serving it now. In course of the day, I'll serve.
As requested on behalf of the estate, leave this matter on 1 week.
Item 46.
May I please, yours. And here the petitioner was appointed as the professor as at annexure 1, my lord. May kindly have a glance. This is the appointment order, and at page 15, my lord, the terms and conditions of the appointment may draw my lord's attention to clause 5, my lord. Page 15.
You are appointed as professors.
Professor on contractual basis, my lord. On contractual basis. Professor on contractual basis. In a medical college, my lord. After retirement, my lord, the post was lying vacant, and I was called upon through a process of selection, and I was given that post, my lord. I had already worked more than 45 years in the same college, and thereafter they had appointed me on a contractual basis. And my lord, may kindly have a glance at page 15. Say, clause 5, my lord. Terms and conditions of the appointment model. May I please, my lord? The appointing authority can terminate the tenure of tenure.
Which
of
page you are pressing?
Page 15, my lord. Annexure 1 starts from 13, my lord, page 15.
Yeah.
The terms and conditions. 5, my lord. The appointing authority can terminate the tenure of by serving a notice of 30 days. The concerned faculty may also resign from the post on 30 days notice. Then, my lord, may kindly have a glance at 7, my lord. 7, the faculty shall be relieved as and when the post is filled up by regular selection or promotion, my lord. This was the common appointment order where the assistant professors and the professor were appointed. Now, my lord, Annexure 2 was issued on 22/6/2023, where these assistant professors, the list of assistant professors were given, where they were given a notice that your appointment will be terminated after 15 days, after some time. And that was against the my lord.
Which order you are challenging?
My lord, the order passed by Honorable Single Judgment.
Which dated?
My lord, 1/8/2023.
Come to 1/8/2023.
Come
to that order.
My lord. My lord, the Honorable Single Judge had directed me to represent before the authority, taking it, may I place, my lord, taking into account the submission made, the petitioner is permitted to make fresh representation before the appointment. Now 3.
This order is not applicable.
Well, here what has happened, my lord?
Sorry.
Exactly similar matters. Interim order has been passed by the same honorable court. I have mentioned the numbers also. That's why I was placing, my lord, Annexure 2. This basing on this Annexure 2, interim orders has been passed and they are continuing. The assistant professors are continuing till date.
So did you make any representation?
My lord, I have made a representation.
In the light of this order 1/8/2023.
My lord, I'll take instruction on that, but what I think.
So you made representation and you challenge the order?
I'm not sure, my lord. I'll have to take instruction.
The appellant has put to challenge.
May pray, my lord. What exactly has happened by now is that they have filed one counter.
Period has already elapsed, Mr. If you have not filed, because 2 weeks time was granted to you to file.
My lord. Now, in the meantime, they have filed a counter where they say that the process for promotion, the DPC has already been held. And in the meantime, maybe that post has been filled up. May I pray, my lord, this case, because similar matters are already
we interfere with the orders when the orders are erroneous, illegal, contrary to any provision.
But here what has happened that exactly in same issues, the orders has been interim orders.
No. Here is a case where an order was passed giving you liberty to file representation.
My lord.
You filed representation.
Well, the same authority who just removed me from the service, the same authority cannot now. I was challenging the action of the same authority, the director, my lord. And my lord, I was asked to represent to the same authority. Then, and my lord, that's appointment order, the common appointment order. Out of that common appointment order, 6. Assistant professor, the case of the assistant professors were entertained by the Honorable Single Judge and interim order has been passed. Whereas in this case, I was working as a professor. And my lord, this person had already worked more than 45 years in the same institute. And in fact, he was supposed to be dealt with a bit respect because he's a professor, my lord, retired professor. After that post.
Nothing can be done.
But what I pray, my lord, that once the other cases are pending, my lord, may I pray that my lord may dispose of the same, saying that my lord, that clause I presented, my lord, that this post can be filled up on promotion, because in the meantime it has that post has been filled up by promotion. This become instructors. My lord may say only this much. Well, my prayer is that. I have challenged on the ground that they have violated this clause 7. Clause 5 and 7 of the...
No, you are not sure whether any representation has been made in...
No, ma'am. No, ma'am.
Not sure.
Not sure.
The petitioner has put to challenge an order dated 2023 passed in WP bracketed C number 24116 of 2023, comma, in the present intra-court appeal. Stop. The operative part of the order which is under challenge in the present appeal reads as under paragraphs 4 and 5. So top. Learned counsel for the appellant has expressed his inability to inform this court as to whether any representation was filed in compliance of the aforesaid order of this court dated 1/8/2023. So stop. We further, we do not find such infirmity in the impugned order which would require this court's appearance in an intra-court appeal. So stop. The appeal, in our opinion, is devoid of merits and is dismissed accordingly. Yes.
Item 47.
Item 47, the pleadings are complete, my lords. Can be heard tomorrow, my lords. It will take about 15 to 20 minutes, half an hour.
As requested on behalf of the petitioner, list this matter on tomorrow. Tomorrow.
Item 48.
Obliged.
In this case, I am filing also affidavit, my lord, adopting the counter affidavit filed in WPC number 24338 of 2023.
No, in next case, 48.
47 interim order till tomorrow. Maybe extended.
47. You are in which case? This case.
48. It's not in. 47. Already I have it.
47, we have an interim order till tomorrow. Maybe extended.
Interim orders are continue in the meantime. Which you are adopting?
In the item 48, my lord, not in 47. 47 the pleadings completed.
48. My lords, 48 is short point for your lordship's appreciation, my lords. The first matter, your lordship may have the first matter, that is 17626 of 2020, extremely limited point. Lordship may turn to lordship's last order.
48 is 17626.
First matter. First, all the batches are same, my lords.
All right. How many?
There are 5, 6.
7, 8,
7, 8, 9, 10 matters. 10
You
matters.
want us to see which order?
Only, my lords, order number 3 in WPC number 17626 of 2023.
Yes.
The point has been, my lords, crystallized by your lordship. If your lordship bears with me, my lords, and permits me, I'll read this, my lords. The sole question, paragraph 3, the sole question raised before this court is that the revised additional demand has been raised by the opposite parties, relying upon a letter dated 7/4/2022 of the state government, addressed to all the collectors of the state. It is contended that the petitioner, being the highest bidder, in terms of the agreement executed between the parties, the agreement incidentally was executed way back in 2017 when he was declared the highest bidder. He has complied with regard to the dues paid by him, and as such, the state government has already acknowledged the dues. And after accepting the same, contrary to the agreement and statutory provisions, the state government issued a letter dated 7/4/2022. Therefore, whether the state government is competent to raise a demand claiming revised additional demand or not, to that extent, Mr. P.P. Mahanti, learned additional government advocate, seeks time to obtain instructions by the next date. So what has happened here, Manoj, the case is very telltale. As a sample, your lordship may kindly take page 29 of the first brief, annexure 2.
So whether this instruction has been received?
Yes, they have filed a counter.
No, I have already filed that.
They are saying the additional.
I have already served.
Here, my learned friend has served me the counter. Lordship may kindly have page 37, annexure 6. It is telltale on the face of it.
Page?
Page 37, annexure 6. Payment of revised demand. This is to intimate you that at the time of auction of Donkari BSQ number 3/9 dated 25/9/2017, the rate quoted by you was 130 plus 133, my lords, for which you had been adjudged as the highest bidder. Accordingly, demand notice was issued after receipt of environmental clearance from competent authority. This demand notice, incidentally, I'll take a pause. We have paid that 1 crore and odd. However, on scrutiny of the case records, it has come to notice of this office that the additional charge has been substantially enhanced by the district level committee to rupees 130 plus 295 and approved by the collector Jajpur based on the instructions received from the Office of Additional Chief Secretary, my lords, R&DM, Revenue and Disaster Management Department, wide letter number so and so dated 7/4/2022. Now in 2017, my lords, they hold an auction and the bid is knocked down in my favor at the rate quoted there, my lords, 253 and odd. Now I pay. And then, my lords, the agreement is also signed with me. Post signing of the agreement, after it becomes a binding contract, then in some other queries, naturally because some time has elapsed in the meantime, because the mining plan took some time to get cleared, in some other neighboring queries, the rates have gone up. So the Additional Chief Secretary, my lords, takes a decision and forms a district level committee. Now, district level committee formation is nowhere authorized under the Act. Under the Act, it's only the Tahsildar who's to call for the, my lords, the auction, and the controlling authority is the collector, a sub-collector in this case, my lords. He, my lords, forms a district level committee and directs whole across the board that all the rates must be, my lords. He takes a mean average of 3, 4, or 5 queries at a much higher rate. And he directs that all the queries rates will be substantially revised in accordance with that rate, the subsequent rate, in the midst of the agreement, my lords. Now, this is, my lords, squarely hit, my lord. First of all, this is a void, my lord. The demand itself is not borne out by or supported legally by any of the provisions of the Act. As your lordship will appreciate, the Act does not permit. And once the bid is knocked down for 5 years, my lord, and the agreement has been signed, my lord, is sacrosanct, binding between both the parties. Even the state is bound, we are also bound. They raise a minimum demand, we have also paid the demand, they have also accepted the demand. Now, at this stage, can they really do it? And there were several Supreme Court judgments, my lords, on that light. My lord, the fundamental proposition we are posing the question. That was the point on which, my lords, your lordship crystallized it and asked my learned friend to file a counsel. So we thought that since, my lords, the point is absolutely limited, whether really a rejoinder may not be necessary because it's on the merits. Whether they can justify this later on. That's the point.
Yes.
No, Lordship, kindly see my counter affidavit, my lord. In view of the letter, it is 7/4/2022, my lord.
Which page you are facing?
My lord, page 11, my lord.
No, this is
Internal
not
page
in
11.
dispute that the agreement was complete in.
That was completed.
Then how can you deviate from that?
Smile. Not in view of the government letter, my lord, because there are some illegal mining and to fix the minimum guarantee. So thereafter, pursuant to the government letter, the one committee was constituted and committee has taken decision and fixed the additional charges and minimum additional charges at page 15.
No, whether there was any illegality in that auction.
No. In view of the committee decisions, the additional demand has been raised.
That's the point.
We will take up tomorrow.
Great. Great.
A copy of the counter be served on
Yes.
You
I mean, sub item 10.
So in all these cases, similar issues are.
Well, same
Similar
issue, yeah.
issue is there.
Same limited point in all the cases.
Forty-nine.
May I please, your lordship?
My lord, item 49, I pray for an adjournment, my lord.
Your lordship, kindly see the several time, your lordship, the state has taken time for the filing of counter, your lordship.
Madam,
Not state.
Madam, my counter is ready. I'll file by day after tomorrow.
Yes, sir.
And counsel for the state states that a counter affidavit shall be filed by a day after tomorrow.
Oh, please, your lordship.
Stop. This case on 2 weeks. To stop time in the meanwhile shall be may be utilized by the petitioners to file counter affidavit. Petitioners or petitioner?
Petitioners.
By the petitioners to file counter affidavit. File rejoinder if so required.
Oh, please, your lordship.
Yes.
Item 50.
Item 50 can be taken tomorrow. The case, batch case is there. So it's ready, my lord, but let's see. Time is there. About
All right. Tomorrow.
Can it be on next Monday?
Next
Next week? Next Monday?
Next Tuesday is.
Yeah.
Next Tuesday.
I have jointly requested. Does this matter on next Tuesday? I'll decrease the number of cases.
Yes, yes.
Which
Lots
are
of-
listed before
Yes, it was.
this bench. And only.
Small point is involved in this.
In the matter where we have to file a reply. We have 51. Your lordship,
Senior
grant me
counsel.
10 days time or week after thereafter. not
Seek
the-
the adjournment to.
We are for the corporation whose tender
Counsel for
election of
the
the.
corporation.
Yes, madam. Orissa Hydropower Corporation.
And counsel for the Odisha Hydropower Corporation seeks adjournment to file a counter affidavit
I only pray, my lord.
within 2 weeks.
Within 2
weeks. This case on 2 weeks.
Item 52.
Item 52, my lord, I pray for some time to comply with the order dated 9/2/2024, my lord.
Counsel for the petitioner seeks adjournment to comply with the order dated 9/2/2024. So,
Can-
as requested, just this matter on
Can I pray for March 4th?
2 weeks.
Can I pray for March 4th? 4th of March. Can I pray?
That is 2 weeks, that is 4th March. Item 53.
Oh, bless me.
May I please, your lordship. In this, your lordship, an additional affidavit is to be filed, your lordship.
Additional affidavit.
And the interim order passed earlier to continue, your lordship.
54.
The petitioner, 80 years old lady, my lord. 80 years old lady is being deprived of to get the family consent in spite of the order. Some, my lord, some services of my husband were not verified because of non-availability of record. So rule 79 of the railway pension rules.
We'll ready with this reply, my lord, or we keep to next week, you will file the so-called, serve the copy to land trail.
We are adjourning and we will give you time to file
Yes,
reply.
yes, my lord.
But in the meanwhile, please ensure
Yes, my lord.
that order is.
Already I asked the officials to come and I'll see that what best can be
We
done.
are
We'll
giving
file.
you 2 weeks time instead of 1 week.
Obliged.
Right, but please comply with the order. And if you, even if you
I'm
don't file any
grateful.
reply,
Yes.
we shall be happy.
Well, I'll
You
try
are in
my
a
best to
position to tell the court that the order has been complied.
Yes.
Obliged.
As requested on behalf of the
Railway.
Union of India. Union of India.
Yes, yes.
Union of India. This matter on 2 weeks for 2 weeks to report compliance of this court's order, violation of which has been alleged in the present contempt application.
I beg pardon, my lord. Item 52, I forgot Interim order to continue, my lord.
Interim order 52.
Item 55.
Obvious, my lord.
55, the matter might take some time. There's a writ appeal, there's an interim order. And reply also, I don't know if.
Yes, so we'll reduce the reply. Let's me keep it to next week or after 10 days.
What a subject to lordship's convenience, I don't. Only the interim order has to be continued.
As jointly requested, this matter on 3 weeks. So the interim order shall continue with the meanwhile.
Okay.
Item 56.
May I please, let's see.
Last.
Shall be filing counter today.
Yes.
My lord, seeing the seriousness of the matter, my lord was pleased to issue notice on the lead petition as well as the in the II application, my lord. And my lord, senior are subject to address this court on point of instruction, and it is completely. I am questioning the act, my lord. This annexure 2, my lord, it's completely violation of the act. That is my humble submission. It's purely question of law.
We'll see.
No, so far I am concerned, I am for the OP number 1. I will file my counter affidavit. Your lordship may grant me some time because it's a PIL where an institution is being taken over by the state government. Now they oppose that it should not be taken over. That is the question only. So I want to file a counter affidavit. Your lordship may grant me some time.
My lord, my humble submission. Let them take time, my lord. My lord, the annexure 2 minutes given effect to till then, my lord. Because it completely violates the act. I can satisfy, my lord.
2?
May not be given effect to till the.
Oh, what is the annexure 2?
My lord, that is the taking over of the school.
That is by way of an act.
No, my lord, that is my humble submission. They are violating that. Act speaks something else. And they taking it over, taking the plea of section 34 of that.
All right, we will see it. As requested on behalf of the respondents, this matter on 3 weeks. So as to enable them to file their counter affidavits. You have filed. You also filed in the registry.
I am filing the counter affidavit today. Yes.
File it in the registry.
You are for the opposite party number?
2 men.
All right. Yes.
May I pray a date, my lords?
All the 3 weeks. 11. You will get a date. You can calculate and come.
On the amendment.